Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Good morning, everybody. Welcome back to J is for Justice. I think it's day 8 of the Nicolae Miu trial. Did I forget to put not guilty? We'll redo the poll. I'm still waking up. Cheers. First coffee of the day. Actually, second. But these are little cups. How are you guys doing this morning? We're going to talk a little bit about these added charges want you to take a listen to this really quick.
On the Apple River nearly 2 years ago. He insisted over and over again he reacted to defend himself and protect his own life.
When you felt the pain about your throat, did you see anything that refreshed your memory about what caused that pain to your throat?
After watching the video, yes.
Okay. What happened?
I got hit in the throat.
Do you remember that now?
Yes.
If I can. Showing you the slides 2993, 2994, and 2997. Is that you?
Yes.
What's happening to you there?
Somebody is going for my throat, squeezing my throat.
Do you remember how that felt?
I felt pain. I couldn't breathe. Scared, afraid.
And showing you the next set of slides here, 2998, 99, and 3000. What did you think was going to happen to you in that moment?
The whole time I felt like I was going to die, so basically I feared for my life.
And in response to that, here's slide 3000. Did you do something in response to that?
I reached out and stabbed him.
Reach out and touch someone.
When you used your knife, and again, this is open-ended, you can ask it any way you want. Were you trying to kill somebody?
Absolutely not.
What were you trying to do?
I was just trying to defend myself.
Just trying to defend myself. The charges Miu now facing have evolved over the last 24 hours.
Okay, so that's what we're going to talk about. They have added lesser charges for the jury to consider. Now, listen to this. He's going to go through them.
Prosecutors adding what are called lesser included counts to that top charge of first-degree intentional homicide. A reminder, if this jury convicts on first-degree murder in the state of Wisconsin, Miu looking at a life sentence. But this jury now also gets to consider second-degree intentional murder, as well as those first and second-degree reckless homicide counts in the stabbing as it relates to Isaac Schumann. Meantime, additional counts have been added into the attempted murder charges involving the four who were stabbed and survived their injuries. Of course, that's A.J. Martin, Riley Madison, as well as the Carlson brothers, Tony and Dante. You can see attempted murder as well as counts of first and second degree recklessly endangering safety. Here is Miu yesterday answering questions about the stabbings under an intense cross-examination.
Tony Carlson never punched you, correct?
Correct.
He never kicked you, never pushed you.
Objection.
All right, let's try that poll.
No.
And you turned around and you stabbed him twice, right?
I couldn't see. I couldn't hear. I didn't know who was punching me, touching me, shoving me, nothing. I was fearing for my life.
You stabbed the guy who tried to break up the fight twice, right?
Objection. Form.
Can you imagine the jury instructions when they give them? Good morning, Leo. Good morning, everybody. Good morning, Zoomer and Wanda. Good morning, Ed Gain. Always good to see you. Stace, Bridget, Suze. I don't know. So let's see if we can look up. I tried to Google it. It's not felony murder, so this is second degree intentional homicide. Let's see what this says. Oh my God. 60 years? Okay, so it's not life, but it's 60 years. You guys, y'all. Either way, it's life. 60 years for the second degree intentional. Y'all, don't commit unalivings in Wisconsin. Whew. But he's still going to get a life sentence. Good morning, Interspace. What? 29 pages of jury instructions? What's up, Amir? Hey, Shannon. Bring it all in, Shannon.
Bring it all in.
So the second-degree intentional homicide carries a less severe penalty of 60 years in prison. What was the other? Let's see. First degree attempted, second degree attempted, first degree recklessly endangering safety. Let's see what that carries. First degree recklessly endangers. I'm still waking up. Endanger safety, Wisconsin. Let's see. First degree recklessly endangering safety. Whoever recklessly endangers another's safety under circumstances which show utter disregard for human life is guilty of a Class F felony. Let's see what the sentence is. Up to 12 years. Jesus, man, they really get you. Up to 12 years and 6 months in prison. That's still, man, 12 years. Even the reckless is fucked. 12 years for being reckless? I think they will find him guilty of this reckless. Is it first or second degree reckless? First and second. They're trying. It doesn't matter. If he gets first and second, he's probably going to be gone till he dies. Let's see what second degree is. Because look at how many counts there are. 4 counts. So if you take 4 counts, let's say they find him guilty on the first degree recklessly endangering. 4 counts. 12 years times 4. He's done. Second degree recklessly endangering is putting a person's safety at risk but not acting with utter disregard for human life. This is a Class G felony. And the sentence for that, wait, second degree recklessly endangering safety. I can't find that one. Class G felony. You're my cat. Up to 10 years. So one's 12 years and one's 10 years. Good morning, Frankie. Good morning, Franny. Good morning, Travis. Good morning, Trey. If I missed you, good morning, everybody. So either way, up to 10 years, and then he's got 4 of those. That would be 40 years. So either way, they want to put him away until he dies. On any of these charges, guys. Even though they added lesser charges, it still adds up at his age to keep him away for life. So either he's gone for life or he gets not guilty. So it doesn't really matter what they find him guilty of. To be honest, if you think about it, the lesser charge of second degree recklessly endangering safety would be 10 years or 40 years with the 4 counts. That's the lesser charge. So it's either guilty or not guilty at this point. Can we agree on that?
Murder, as well as counts of first and second degree recklessly endangering.
I didn't know it was on already.
Language from the jury instruction book.
Here we go, guys. Thank
Authored
you
by
so
the jury
much,
instruction
Llama.
committee. It's a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue their respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions, Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So
God,
it was one of the bracketed instructions. It's on page 3.
Yes.
Good morning, everyone coming in.
It's a
Look at
single
that guy on the
sentence
end looking
paragraph.
straight ahead. What did someone call him yesterday? Stacy, I
removed.
don't know. And then added after, like.
Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be
29
provided with
pages.
a few copies of the printed instructions in the
Chad
deliberation
Gable
room
works at 10:30
for their
today.
reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi,
Don't sleep.
346
No.
Wisconsin 2nd, 289. It could, if there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's, this is the appellate review standard, if there's prejudice as a result.
Which juror?
4021.
God, that prosecutor, I can't. Like, sit up straight, dude.
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Investigator Schultz.
You swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth.
He's the narc.
Please have a seat in the witness chair.
What kind of shit is this? Oh, is it the 90-year-old? Oh, I'm going to be so
Anderson.
mad.
You've already testified, but can you please state your first and last name?
John Schultz.
And
You schmuck.
were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial where period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And you
And
didn't say anything?
she was dozing off and appearing to startle awake
Yes.
multiple times?
Yes.
Hey, Ange.
And from reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson?
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't
Review the
recall the
video.
time. I
Review the
apologize.
video.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross-exam?
It would have been during her direct exam.
Are you making it up?
And that was the, before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
It was row.
I apologize. I think I'm getting confused. It was during the playing of the video,
Was it at any time other than during the playing of the video?
not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after, or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
Joanne
During the break, I just told the
Joey
attorneys
my
that
bad.
I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say, rough?
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was,
Correct.
it was only during the playing of the video?
Correct.
It was only during a portion of the playing of the video?
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video?
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment, or would that last for 10 minutes, or you don't know?
I was not watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment, and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused again. Yes, that is what I would see.
I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back, and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning...
Continuous? No, sir.
All right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes, you can't
Do
say.
you mind pulling your microphone
Correct.
down and then aiming it up at your
You just
chin?
essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
Okay.
This guy's a douchebag. Kay, you are amazing. Dude, get this guy off the stand.
And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
Would that be a fair estimate?
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed,
Here's this schmuck's
it was again just
mugshot.
a brief glance, you weren't dialed in, focusing on her, agreed?
Yes,
You agree with that?
I do agree.
Nothing else?
Mr. Anderson?
So the 4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed, and then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Hey, Island, have fun painting.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those were the only times that I had looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes,
Nothing else?
What a loser.
You said it was only during the playing of the video, agreed?
yes,
You understand that the video was less than an hour, correct?
approximately an hour, yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that, you couldn't have been observing this for over an hour, agreed?
I object that we played it for 56 minutes.
The record's,
56 minutes.
it wasn't over an hour, agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation, agreed?
Agreed.
So you don't know if it was 15 minutes into the video, 30 minutes into the video?
He's
You
lying.
can't say.
I cannot give you an exact time, no, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct, yes, sir.
And you're not in a position to say whether her head was down for any continuous period of time, agreed?
Agree.
56
That's all,
minutes and the
Judge.
judge didn't notice?
Thanks, Judge.
Down.
He's the only one that noticed? Hey, Maisie.
Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I ask that the court strike juror 4021 as one of the alternates.
Mr. Nelson?
I don't think they've established a factual basis that she was sleeping. I think that there's
Yeah, as much.
reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree. There are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive,
yes, Judge.
certainly nothing that would allow me to make such a significant finding. I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different.
What the French call
I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point, too, is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
Anything else from the defense?
Just like a break before we get into openings.
We will. Yes.
Replay crew. He's like, even if she slept through it,
All right, let's take a short break. We will resume at 8:45.
We got 15 minutes. Wow. How terrible was that? That guy's a douche. So he's the only one that saw it. He thought that he was going to sit there and say that in a time span of 56 minutes that he's the only one that noticed that a juror was sleeping and the judge didn't. So number one, the judge is going to be like, fuck you, dude, because I'm the judge. This is my courtroom. And you're going to sit here and tell me for an hour that I wasn't observant enough to see this lady sleeping. So what a bunch of jerks. Wisconsin is a very, very bizarre state with the law, isn't it? Cheryl, it was a cop. A cop. Here, you want to see it again? Here, let's rewatch. It was actually quite comical. He's got, it's this guy with the long hair. He Michael McDonald. No, 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 no. You are my brother. Robin
Not on
says he
Dreams.
looks like the lead singer of the Doobies. You don't know me, but you're my brother.
Instructions.
Whatever the fuck he sings. Y'all, I need more coffee. But this guy here we go.
Sir.
At portions of the trial, were you watching
Taking it to
the
street.
jury?
I was.
Was there a specific point during trial where you, period of time, I should say, where you noticed
More black water.
a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
Did that, was it, what kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to startle awake
Yes.
What's the
multiple times?
Yes.
full belief?
And from the, reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Oh, man.
Nothing else, Judge.
Mr. Nelson?
What time did this occur?
He's like, I don't know.
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Sybil, you're
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross-exam?
I agree, Moondance.
It would have been during her direct exam.
And that was the, before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video,
Was it at any time other than during the playing of the video?
not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
Thank you.
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say,
Oh my gosh.
rough?
Thank you.
Yes, sir.
You,
Flo just gifted 10 memberships. Thank you so much, Flo. That was so generous of you. Welcome all the new members. Wow. Kelly, Reba. Now you can join Discord without worrying about, you can get in there easy now if you connect your YouTube to your Discord, guys. Kenny Knackers, My Three Sons, welcome. Kaylee, Shaz, Lisa B, K-Town, and Pink Nasty, welcome. Oh, and Indie Girl. Indie Girl came in there at the very end. Thank you so much, Flobo. Damn.
during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was
Correct.
It was only during the playing of the video.
Correct.
It was only during a portion of the playing of the video.
Correct.
I keep forgetting love will never be the same again.
And your observation
Now that's stuck in my head.
was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment, or would that last for 10 minutes, or you don't know?
I was out watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment, and then she would bring her head right back up. That's what you observed.
Yes, sir.
Sounds a little naughty. Okay, so the guy straight up pretty much lied, and then the judge decided, no, the juror stays. Okay, we're not playing these games. But they did add, if you missed it, they did add more charges that the jury can consider, and they're going to go over all these instructions. It's probably going to take a while. So there's the first-degree attempted homicide, 4 counts. Second-degree attempted homicide, 4 counts. First-degree recklessly endangering safety, 4 counts. Second-degree recklessly endangering safety, 4 counts. So the lesser of all the counts would still be 40 years. would be 40 years anyway. So that's why the poll is just straight up guilty, not guilty, or hung. Because either way, at Nicolae's age, he's going away for life. Either way, it's a life sentence. It doesn't offer me PayPal, straight to Streamlabs. Tried signing in with YouTube and denied. Let me take a look at the site. I'm having problems and this is not good. Is this what it looks like for you? You put your username in there and then you click tip and then it should take you to where you pay. I checked my settings and there was nothing wrong with it. I don't know. So Chad Daybell starts here in about less than an hour with opening statements. So that might be something I'm going to have to play catch up on because I'm going to be all over these closing statements.
You have a busy life of your own, of course.
In less than an hour, I will be live on my other channel. Please do sub up over there because we probably will be utilizing it as we get into a lot of these trials. Because there's just only so much the streaming center can handle. It took you to Streamlabs. It wants me to log into Twitch. That is so bizarre. I'll check out the settings. It had me update, like it has to log into Stripe, which processes some of the payments, but I updated everything. So I'll check it out. But make sure you guys are subbed up to Gen X TV. I know it doesn't sound like a trial channel, but it's going to be. Yes, we got to get Chad's chin back. Thank you for reminding me. I think I just downloaded it the other day. I keep forgetting. I can't believe they tried to get that. That had to be the 90-year-old they're trying to get off there. They think that 90-year-old's going to throw a monkey wrench in it. And you know what's crazy is that the 90-year-old doesn't even know that they did that. Hi, Bunny. That's weird that it wants you to log into Twitch. Okay, I'm on the site. Let me see. I keep forgetting. I had to log into Streamlabs using YouTube, and then I was able to tip last night, if that helps. That helps a lot. Try logging into Streamlabs with your YouTube account. You shouldn't have to type anything in. See if that works. I'm sorry. Thank you for trying. I just want to be able to figure out what's going on with it so I can fix it. I can't find my chinny chin chin. Where is it? Oh, here it is. By the hair of my chinny chin. Thank you, Miss Robin. But if you go to tip and then if you log into your YouTube, you have to make sure it's your original name though, right, Flo? Something about the original YouTube name. I just want to get it ironed out so that we know what's the matter, because there's no error on my side. It's okay, Flobo. I appreciate that. I tried. I get an error trying YouTube. Try using Google Chrome, I guess. Yeah, everything works better on Chrome. If you're using Safari, that might be why. If you use DuckDuckGo, you can't tip. Probably because DuckDuckGo hides your identity. You know, I'm glad the Crumbly's got a harsh sentencing, but it made me super angry knowing Ferret Boy only got 5 years. I know. Flo said she only had to log in once. If y'all have multiple usernames on YouTube, you have to make sure you're using Google Chrome and you're logging in with your YouTube name that you're using here, I guess. Because if it's working for some and not working for others, it banned you, Diana. What? You had to re-sign back into YouTube. Well, let me know. I mean, I'm putting these together as I'm seeing your feedback. Like when you go there, does it give you the option to choose anything, or you can't even see the tip page? Let me know. Give me your feedback. It's 9:47. Where are they? They're 2 minutes late. I just need your feedback so I know what it's doing, because I can let Streamlabs know that it's glitching, that I need help. I just need to know exactly what's going on. Because it's working for some, and then other people are getting an error. So I don't... You blocked Streamlabs? Okay, we're back in court, guys. Here we go. Oh, with white noise in our ear. I should have known. Oh, Joey Bag of Donuts. What kind of shit is he? Look at that. Look at the judge. Speak up on his desk. What's his deal now? He is obnoxious.
Good morning. We are ready.
Here we go.
To
jury instructions.
deliver the jury instructions, and then the attorneys will make their closing arguments. Here's how the day will work. I will deliver the jury instructions to you. That'll take some time. I will have them displayed up on the board so you can follow along, but I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofasi will deliver Mr. Miu's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Ready. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Miu is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nicolae Miu committed crimes in St. Croix County, Wisconsin, on July 30, 2022. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Miu in any way. It does not raise any inference of guilt. In count 1 of the information, Nicolae Miu is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Miu is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime. Both intentional and reckless homicide require that Mr. Miu caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that Mr. Miu acted with intent to kill. First and second degree reckless homicide require that Mr. Miu acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death or which causes serious, permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Miu reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Miu had the opportunity to retreat with safety, whether such retreat was feasible, and whether Mr. Miu knew of the opportunity to retreat. You should also consider whether Mr. Miu provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Miu is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of second-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of first-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. Mr. Miu is guilty of second-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding of whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide, or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find Mr. Miu not guilty. The facts necessary to constitute each crime will now be defined to you in greater detail. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find Mr. Miu guilty of first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Miu caused the death of Isaac Schumann. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu acted with the intent to kill Isaac Schumann. Third, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The words intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, one, that Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or two, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are not to be concerned, I'll start over. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu caused Isaac Schumann's death with the intent to kill, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Mr. Miu is guilty of second-degree intentional homicide. Before you may find Mr. Miu guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu caused the death of Isaac Schumann. Second, Mr. Miu acted with the intent to kill Isaac Schumann. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of Mr. Miu would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in the circumstances of Mr. Miu would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in the circumstances of Mr. Miu would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Miu's position, under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schumann with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Miu guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree reckless homicide, the state must prove, by evidence that satisfies you beyond a reasonable doubt, that the following three elements were present. First, Mr. Miu caused the death of Isaac Schumann. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schumann by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Miu is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schumann by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of those foregoing offenses. Mr. Miu is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Miu is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Miu is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree recklessly endangering safety or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide and first and second-degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second-degree intentional homicide require that Mr. Miu intended to kill another person and Mr. Miu did acts toward the commission of that crime which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. First and second-degree recklessly endangering safety requires proof that Mr. Miu recklessly endangered the safety of another human. First-degree recklessly endangering safety requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. For count 1, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows. Mr. Miu is not guilty of either attempted first or second-degree intentional homicide or first or second-degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Miu is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Miu not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Miu guilty of attempted first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu intended to kill the named person. For count 2, the state must prove Mr. Miu intended to kill Alexander Martin. For count 3, the state must prove that Mr. Miu intended to kill Dante Carlson. For count 4, the state must prove that Mr. Miu intended to kill Anthony Carlson. For count 5, the state must prove that Mr. Miu intended to kill Riley Madison. Intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The second element, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or, I'll start over. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Miu's acts under the circumstances. Another person means anyone but Mr. Miu and may include the intended victim. An extraneous factor is something outside Mr. Miu's knowledge or control. The third element, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. you should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or, 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Miu is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser-included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. Before you may find Mr. Miu guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu intended to kill the named person. Second, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some extraneous factor. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that Mr. Miu not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in Mr. Miu's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in Mr. Miu's circumstances would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in Mr. Miu's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Miu's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from the standpoint of Mr. Miu at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Miu is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser-included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 3 elements were present. First, Mr. Miu endangered the safety of another human being. Second, Mr. Miu endangered the safety of another by Mr. Miu endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors. what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. We should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu recklessly endangered the safety of another, those named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Riley Madison count 5, and the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser-included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Miu is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in Section 941.30, Parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of the foregoing offenses for each count.
Sorry, Judge. Could we take a brief break, please?
Yes, please take the jury out.
All rise for the...
Are you kidding me? A break in the middle of that mess? Oh, man. Y'all, this is a mess. What's Joey Bag of Donuts' problem now?
Let's return in 5 minutes, 9:40. What's that? No, I just wait.
No, you didn't miss closing. This is jury instructions. We've got Chad Daybell. We're still waiting for Judge Boyce to open up the courtroom on Chad Daybell. Nope, you didn't miss. This is all because they added more charges, Karchi.
And good morning again from our Fox 9 streaming studios today as you are watching our Gavel Gavel coverage of the Apple River stabbing trial. The jury instructions have been provided there by Judge Michael Waterman. Just on a layman's, as you process all of that, imagine this jury going back into their deliberation room this afternoon and needing to process all of that. As it took, nearly 20 minutes just to read the entirety of the jury instructions. Let me show you the charges Nicolae Miu now facing after the district attorney's office added several lesser included counts. As it relates to the homicide allegation, the death of Isaac Schumann, stabbed to death, Stillwater teenager, 17 years old, killed that day during that Riverside confrontation, July 30th, 2022. Nicolae Miu facing the top count, first-degree intentional homicide, a conviction there, Class A felony, Wisconsin, life sentence. That was the primary charge coming into this case on the what's called the criminal complaint, or the information filing from 2 years ago. But overnight, the state adding these lesser included counts, second-degree intentional homicide, and then first and second-degree reckless homicide. You heard the judge describing it. You begin at the top count, then you work your way down. If you find him not guilty or acquit him on that first count, you go down, take a look at the statute as it relates to second degree, balancing the utter disregard for human life, the reckless nature, versus Miu's claim of self-defense, the fear of great bodily harm or death in the river that day during that escalating confrontation that unfolds over the 3.5-minute Juwan Cockfield video. The second screen we have here are the attempted murder charges. Those two have been amended overnight to include the lesser included offenses. We'll take a look there. 4 counts, 4 people stabbed that day, all of them in the so-called Carlson tubing group. Remember, they're 100 feet away over on the sandbar. They see the loud interaction between Isaac Schumann and his Stillwater teenage friend Juwan Cockfield, Alexander Vang and the others. They come over thinking they're going to be peacemakers. There's this confrontation.
Come on. They come over thinking they're going to be peacemakers while their daddy told them to, what is it, post up? Post up. So they added these lesser charges, but don't let it fool you, because each charge still carries 10 years. The less charge still carries 10 years per charge. Trolls will be blocked, no questions asked. So have fun trying to troll here. It won't work, as our mods don't play. Judge Boyce still has not opened up Chad Daybell. Jeanette says she sat on a jury that took 3 days to decide what the jury instructions meant. No, they have not, Stacy. No, I think we get him pretty quick, Amber. So if he is found not guilty, he will still get at least 10 years. Yeah. Per count. There's 4 counts. Is that what he said? The guy looked like a Sasquatch? Unfortunately, Stace, there's always, when you stream trials, there's always trolls because you're streaming for so long that they look for live streams to fuck with. Kristen, it's good to see you green again. Reba says, how long do we think jury deliberations will take? With all these instructions, it seems like it's going to take a while because they're going to have to go through each charge and they're going to have to go through and fill out their paperwork for each charge. His wet hair was in his face, so he said it looked like a Sasquatch. They'll probably be deliberating by, let's see, it's 9:42 there. Lunch. Afternoon deliberation. Do you think they'll come to a agreement right off the bat? I don't think so. I think it's very, very complicated. Okay, it looks like, oh no, they're still replaying. Here, let's see what this is.
What is he on? Whoa! Whoa!
And we'll cut out of that for you for obvious reasons. Judge Waterman is standing, as are all the parties. As defendant right in front of you with his attorney Aaron Nelson right next to him on his left. We are nearing 9:43 Central Time, closing arguments about to begin. The state goes first, the defense will follow. The state gets a shorter rebuttal on the back end of that, and then the jury will be sent out. We still do have to get rid of 2 alternates. 12 will ultimately deliberate Nicolae Miu's fate. To the courtroom now.
For everyone in the courtroom, that was a well-timed break.
What is that?
All right, is everyone ready to listen to the judge talk some more? All right.
Let's get back into it.
Picking up on page 20.
Patrice.
In count 6 of the information, the judge alleged that Mr. Miu committed battery. Battery, as defined in section 940.19, parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Miu guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Judge, can we approach quick?
Yes?
White noise again. If I was a juror, I would be sitting there like, what? You thought I was nodding off before?
Every lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Miu committed battery. So let me get to the elements.
Okay, because this isn't confusing at
First,
all.
Mr. Miu caused bodily harm to Madison Cohen. The word cause means that Mr. Miu's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Miu intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Miu had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Miu caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Miu knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Miu did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Miu committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Miu guilty on any of these counts, you must answer the following question. Did Mr. Miu commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Miu committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Miu is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Miu is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Miu's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Miu the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Miu the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts, according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Miu committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Miu's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafazi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge.
Here we go, guys. Closing arguments.
Absolutely senseless and horrific acts of violence. And all Nicolae Miu had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nicolae. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nicolae did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nicolae would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nicolae is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nicolae seeking Dante out and stabbing him when his group is in the opposite direction. Nicolae walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
Can we have the screen, please? So here at 2 minutes and 6 seconds, this is after Nicolae has stabbed the 4 people that you do see. parts of on the video. He's standing next to Ariel. Ariel's there. Nicolae's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nicolae until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nicolae was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. And next you see of Nicolae, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Take it down. Oh, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nicolae admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nicolae, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nicolae walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nicolae and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nicolae, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nicolae's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nicolae punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nicolae towards Nicolae's group. Nicolae turns and stabs him twice. Another one I submit to is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nicolae to leave. In the middle, when Nicolae turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nicolae, Isaac is just standing in the background. He's not saying anything, he's not doing anything, he's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nicolae smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nicolae never said anything about being choked, never said anything about pain on his neck. Even when specifically asked by the SART nurse, never mentions anything. And the video doesn't lie. So on the left, Nicolae has just stabbed Riley, who you heard from multiple witnesses, was just standing there. Tony comes to try to break it up. Nicolae stabs him twice. Isaac, just off frame, I submit to you, he just saw Nicolae stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nicolae. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nicolae's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Can we take the screen down?
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nicolae stab two people who posed no threat to Nicolae. Tony was breaking up the fight. He had actually ignored Nicolae at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13 on 1, implying it's some sort of mob beating up Nicolae. It's not even 13 people yelling at Nicolae. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nicolae's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1. with AJ and Dante. But even then, as you saw in the video, Ariel's right there. So it's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13-on-1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nicolae turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them. Especially if you're so afraid you gotta reach for your knife. You can't be that afraid that he's gotta reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nicolae looking for the phone. So Eric Von Williams from Nicolae's group, you heard testify, before any of this happened, he was concerned about Nicolae's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nicolae not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nicolae went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nicolae. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nicolae. What about Nicolae? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nicolae has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nicolae's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nicolae had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nicolae is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, He was in the Army. He doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nicolae is this feeble old man, they ignore that the only 2 people actually standing close to Nicolae are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nicolae run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nicolae to try to explain this transition. From 0 fear to 10 out of 10 fear, he's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nicolae, the demonic look on his face, staring through people, smirking. Defense argued in opening it's a slide tour here, there. You know after seeing the video so many times that's not the case. When he's not glaring, he's smirking in the video. Recall I asked Ernesto, his best friend, when he was trying to describe the shock of Nicolae, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared, he smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nicolae was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense had tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nicolae punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nicolae just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nicolae did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nicolae punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is arguing on cross, well, she's not wet, she didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nicolae, she gets punched and falls backwards, and then their attention's back to Nicolae because Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nicolae before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nicolae got punched. He didn't have any injury. Defense can't have it both ways. So I'll turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nicolae did. Defense has tried to highlight throughout the trial, Nicolae was in this traumatic experience, give him a break. It's understandable, he made up this huge, all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who's disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nicolae, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nicolae punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and, say, your partner go to the grocery store. Park your car, you're leaving the grocery store, you think your car's parked over there, they think it's parked over here. You still know the car is parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the boys group, that Nicolae struck Madison. So what about, let's talk a little bit about witnesses from Nicolae's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nicolae. Remember, Ariel was there when he stabbed Dante. He was right there when Nicolae stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nicolae when Nicolae has the bloody knife. Ariel denies seeing anything to law enforcement of what Nicolae did. Ernesto, at trial, testified he didn't see Nicolae get hit, just saw him down in the water. Said he couldn't remember Nicolae saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nicolae, get out," Nicolae walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, "I wasn't asked that question." But he described that event. He also wasn't asked more than 10 times if Nicolae said, "They took my knife." So, about the punch to Madison again. Sergio, he's in Nicolae's group. He had walked out a little ways. You can see him in the photo on the left in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nicolae and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nicolae pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nicolae do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nicolae just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, "Don't worry about it." This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nicolae's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as a slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, "I saw some swelling and some slight redness, but didn't see the punch"? Why wouldn't he just say, "Yeah, I saw the punch too"? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, "You can't hit a woman," before Riley is stabbed. They obviously didn't plan this lie in the chaos of the moment, so the only thing defense can argue is they're mistaken. That all of these people standing around Nicolae in that half circle approximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the Carlson group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nicolae's group in a different category. There's the drunks on the Apple River, then there's Nicolae's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nicolae was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison, you heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nicolae, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nicolae got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So, count 6 is battery to Madison Cohen. It has 4 elements. Nicolae caused the battery to Maddie, or caused the injury, the harm, the pain. She testified to that. He intended to cause the harm, despite his denial. I submit to you that's clear. You don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nicolae's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing, the boys. Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do, just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nicolae essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation. And how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nicolae ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it. All right, this is at 1:05 in the video. I'm ready.
Go, kids, go! Go! Go, kids, go! Go! Go, kids, go! Go! It doesn't matter.
You didn't. You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking his snorkel, which was a lie. And he had just ran up on the boys. So, after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nicolae gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nicolae pops right up and disembowels AJ. After Nicolae goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nicolae down on the ground, Tony walks by Nicolae with his back to Nicolae, yelling, "Get back to Dante." He turns around to tell Nicolae to get away, and Nicolae turns around and stabs him. Nicolae was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you the state has proven beyond a reasonable doubt this was not justified self-defense, and Nicolae knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm was imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So, for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nicolae's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He didn't not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nicolae stabbed him again. The one he blocked, you saw the injury, was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nicolae missing vital organs, but for medical intervention. Miu claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound to the torso, the stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nicolae killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, he missed the vital organs of Dante. But for AJ blocking one strike and missing vital organs, he survived. Nicolae said he had tunnel vision. Come here, screen. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. It makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schumann, Nicolae stabbed him so hard he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, oh, sorry, that's part of the third element. So how do we know, what Nicolae believed? What a reasonable person would believe? That there's only one person on the planet who experienced what Nicolae experienced, saw what he saw, was standing in his place. And what did Nicolae believe? He believed it was unjustified. The very first thing he does is walk away, doesn't run, doesn't tell Ariel or Ernesto anything, doesn't tell them to run. He walks away from his group to the other side of the river, at some point rinses the knife because it wasn't covered in blood, throws the knife onto the bank before walking back to his group, says nothing to his group other than they took my knife, puts on his hat, sunglasses, and shirt, and sits down in his tube. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan 1, get away. Slink away with the crowd. That didn't work. Plan 2, play dumb. Can you take the screen down, please?
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature? Temperature's okay in here?
on? Yeah.
Okay.
Somebody,
All right.
I hear somebody got stabbed,
Um,
and I fit the description.
yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names, but you know, that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids
All right.
being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure they're drunk, kids being kids. That's what he told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. You can take it down, sorry. Clearly not in shock. Clearly Nicolae knows that was not justified, and he's looking out for Nicolae. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nicolae actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nicolae did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene with chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when you clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nicolae was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? Do you know what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nicolae's belief versus reasonable person. Here you know, I submit to you, his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nicolae endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. Your jury instructions define criminally reckless conduct. Creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there to utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims, and he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nicolae did not use, he was not justified in self-defense when he attacked these people. So we'd ask that you answer yes on that question. In the end, what is beyond clear, Nicolae knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nicolae, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state has to find Nicolae Miu guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All rise for the jury.
Good Lord, man. All right, while we take this break, I am going to hop over to the Daybell trial. I just boosted the audio over there. It is awful. It is through the court. So bear with me here, guys. We are on my second channel called Gen X TV. Join me over there.
11:05.
Switching headphones.
Madam Clerk, could we just...
I'm going to mute him while we're on break. Well, I can leave him playing. All right, I'll see you guys in Daybell if you're coming over there. I'll be there for a little bit of their opening statements.
All right, good morning again from our Fox 9 streaming center. You've, of course, been watching our gavel coverage of the Apple River stabbing trial from Hudson, Wisconsin. St. Croix County District Attorney Carl Anderson delivering a strong closing argument to this jury, asking the jury to find Nicolae Miu guilty on all of the top counts. He said he's not going to defend the actions of the Stillwater teens. Their behavior appalling, inappropriate on the river, but it does not justify what Nicolae Miu did. Anderson calling it senseless, asking the question rhetorically, why didn't Nicolae Miu just walk away? He points out the made-up stories, the lies afterwards. He says Miu did that because he knew what he did in that moment was wrong, that it wasn't justified. Nicolae throwing the first punch, hitting Maddie Cohen, describing Miu as not feeble, looked past the quadruple bypass that he had recently experienced in his life. Don't look at this as a 13 versus 1. This was 2v1 at most. The 13 were sort of all around, but certainly not in Miu's face at the time. He points out that Wisconsin is not a stand-your-ground state. He has no duty to retreat, and then pointing out the severity of Isaac's injuries, puncturing or shattering through 2 ribs and stabbing Isaac Schumann, killing him with the knife to the heart. Quote, Nicolae was angry, he snapped. Nicolae was not scared, he was angry.
Okay, I lied. I'm back. I can't get into dumbbell right now. I just can't get into it. I don't know why. So I am here for the duration with my ice cold Coke Zero. Oh, let's look at what Meg sent me. Hold on. Is Miss Robin still here? Thank you so much, Roberta. Let's watch this video about Maddie. We're going to watch a video about Maddie's testimony from Court TV. Let's see here.
A witness in the Apple River stabbings case who didn't want her testimony seen or heard could be the person who tips the scales. Maddie Cohen's altercation with defendant Nicolae Miu is what sparked the incident that turned deadly. Now, Cohen says that she confronted the defendant after she saw a group of teenagers yelling at him. Body cam video of the aftermath is the only glimpse we see of her. Take a look.
He punched me in the face. I don't know what the got someone who can't move. Go help him. Please. We're going to help. We got a gentleman down there. His guts are out in the open. Okay.
A transcript of Cohen's testimony lays out what she says about who threw the first blow. So on direct, she said, he strikes me in my left side of my face with his left hand. And the question is, did he hit you with a closed fist or an open hand? She said, I can't remember. I thought it was with a closed fist. And the question is, you don't remember like seeing it coming in though? And she said, everything happened so fast. Then later on cross-exam, the question is, okay, so he throws it with his left. He throws a hook with his left hand, is that right? She said, yes. And he said, and I think you testified that he hit your left side of your face. She said, yes. Question is, okay, so he hit you on this side. Describe how that's humanly possible. Her answer, I actually do get my lefts and my rights mixed up a little bit.
Come on. She said she gets her left and right mixed up a little bit. Do you think the jury is going to believe this? Who was the other ridiculous person that didn't know, was it left from right or what was it they didn't know? Or said they didn't know?
Okay, is that going to be a problem? Let's bring in our guest and talk some more about this. Criminal defense.
Is that all the transcripts they read? Oh, here's more.
Here. So this is from a point in the transcript where she's being questioned by the prosecutor, and she's talking about how she did make contact and put her hands on Nicolae Miu. She's asked, what did you do? And she said, I graciously grabbed the corner of his elbow and I got him back toward me instead of those boys. Did you yank him? No, sir. Did you and Riley's another one of the girls involved in this, did you both touch his shoulders? Yes. Shove him? You didn't shove him or hit him, which is actually an objectionable question there, as you know, Matthew. And she says no, because the defense is saying that she did shove him and was pushing him, and that the strike that he delivered to her was a defensive strike.
I think that shows that they got their stories together, right? They're both saying they don't know their right from their left. Then we have this bish.
Remember everything sequentially perfectly, or is it choppy?
It's very choppy for me.
Okay. So what do you remember next?
I remember getting off the tube, walking up to Mr. Miu, and I just remember Maddie being there and yelling at him. I remember her being punched in the face, and then I remember being stabbed, and that is completely it.
Okay.
The other channel is Gen X TV. Right here, right here. So let's listen to that first part again.
Low. So on direct, she said, he strikes me in my left side of my face with his left hand. And the question is, did he hit you with a closed fist or an open hand? She said, I can't remember. I thought it was with a closed fist. And the question is, you don't remember like seeing it coming in though? And she said, everything happened so fast. Then later on cross-exam, the question is, okay, so he throws it with his left. He throws a hook with his left hand, is that right? She said, yes. And he said, and I think you testified that he hit your left side of your face. She said, yes. The question is, okay, so he hit you on this side. Describe how that's humanly possible. Her answer, I actually do get my lefts and my rights mixed up a little bit. Okay, is that gonna be a problem?
I think it might be a little bit of a problem, to be honest. Yeah. And then the phlebotomist said that she didn't know right from left, and she takes blood. Uh-huh. I think you're exactly right, Roxy. Corey would have liked to see them duke it out or reenact it in court. I know, all they did was keep showing the video. Amber Gloria says added battery charges with zero evidence. Yes, she pokes people for a living and she doesn't.
You're what the French call les incompetents.
They need to tattoo L and R on their arms because they're stupid.
Why are people such idiots?
Jeff Kent just said in the Daybell chat, dead chin walking. Oh my God, Stacy. Yeah, I said when she testified, I'm like, this lady would never be able to find my veins. And Daybell is on a break. Oh boy. We have 31 people watching on Gen X TV. Let's get that number up. If you want to watch Daybell, head over to Gen X TV and let your friends know that we're going to be streaming it gavel to gavel coverage in the J for J studio, streaming studio. We are live in Studio J. Daybell is live in Studio Z. And your left hand makes an L. I never really realized that, but it does. I never had a problem with left and rights. I mean, I don't even know what to say. I mean, that's such a blatant lie.
Don't make me a dog-faced lion pony soldier.
I know. She's like, I don't know what the fuck, but he punched me in the face. Typical drunk drama queen. White girl drunk. I mean, look at her face in that one still shot. She's screaming, get the fuck out of here, get the fuck out of here. And I see this other chat. People are saying Nick was warned. Warned about what? Why does everybody think that these kids had the right to tell him where the fuck to go? I mean, now granted, I have to admit, it was a little odd when he bum rushed the tubes. If they didn't have his phone, I could see where they'd be like, what the fuck? Whoa, 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 what are you doing? But the way they kept it going and made it worse was, I think, where they were wrong. Baby, come back. You can blame it all on me. Why are we singing that? The Carlson group made everything worse. Do you think that this would have happened if the Carlson group wasn't involved? Do you guys think that this would have happened if the Carlson group would have minded their beeswax and not posted up? Carlson group posted up, and that's when shit got real. Who is this lady? Does she have a Stanley Cup behind her? She does. Is that a Stanley? That is the Stanley Cup, isn't it? Not everybody has Honest Abe like I do. I got to get Honest Abe in the frame here. There he is. So, cool story behind Honest Abe. That was my mom's. So, my mom was a huge Abraham Lincoln fan. And I have several memorabilias that were my mom's. And that statue is one of them. She had it ever since I was a little kid. So, Honest Abe is behind us. The video guy in the Carlson group. Okay, we're back live in the courtroom.
Yeah.
Thank you for being here, guys. If you haven't hit that
All right,
like
we are back in the presence of the jury with the attorneys and
Melmo,
Mr.
do
Miu.
you see Honest Abe?
Mr. Truffesy.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing.
Melmo, now that's going a bit
absolutely nothing
far.
to them.
Crotches?
Then,
He did not.
when that man, Mr. Miu, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Miu acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is, the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Miu. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockfield.
You're awesome.
The video perspective that the jury is required to consider it is as Nick Miu is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen, that is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Miu doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So, the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Miu, calling him a raper. I'm not talking about that one. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Miu, right? I think to a person, they testified, yeah, we were really concerned about Mr. Miu. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Miu had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Maddie Cohen, we could have passed. And you heard Owen Peliquin. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Joanne Packfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Joanne Packfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see it. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Miu's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it, they don't say anything about Nick Miu telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that, Nick said that. They find Ariel's phone in the river, so we know that. We know that Nick comes up to the teenager's tubes, and we know that he's looking for a phone, and Cockfield's holding the phone. Joanne Cockfield's holding the phone. We know that Nick Miu walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb. He's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable, so he waves for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him again. He tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Miu, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. They're just like, wasn't me, wasn't me, wasn't me. Well, they're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
Judge, I can't see the exhibits and we do a rebuttals.
And step up and move over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Miu's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
That's right. That's right. What is he on? Whoa! 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 Get away! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Guys, tripping. He's on 4K. Yo, the new iPhone got that good quality. What did he say? Yeah, what the hell? Who is this? Yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Go! It doesn't matter. He said he said he was looking for a little girl! You're looking for a little girl? Yeah! That's exactly what he said. Weirded us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We're trying to have fun. Is he gonna claim you? He's gonna claim you. We don't want this motherfucker. That is on camera. That is on camera. He on camera. Oh God. Oh God, he on camera.
second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Miu has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Miu pushes her out of his space, Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Miu's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Miu committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24 of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Miu. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured. Because it's moving like this. When you break it down to 1/24 of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Miu's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Miu was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Miu was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Miu's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, "Stop, stop, stop." He's not yelling it to Nick Miu. Nick Miu's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know.
He ain't a woman! He ain't a woman! You ain't a woman!
Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Miu's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Miu while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that A.J. Martin, who says he's the peacekeeper, that's what he said, he runs up from behind and shoves Nick Miu while Dante Carlson comes in for thirds and smacks Nick Miu in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man, who had heart surgery, is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what A.J. Martin said in his testimony, when he was shown the picture of him making contact with Mr. Miu before Mr. Miu stabbed him, he said, he got me before I got him, I guess. What does that tell you about what A.J. Martin's intention is? He's back in the water now for a third time after getting pushed down by A.J. Martin. And what do we see next? That's Anthony Carlson. He walks right by Miu. Miu doesn't do a thing to him. Mr. Miu doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Miu has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Miu. And why does it matter? Why does any of that matter? Because if you find the following, Nick Miu is not guilty of all the charges, okay? If you find that Nick Miu believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? If he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Miu puts his hand in his head and says something like, "My life is over." And Brandy Hart says, "I don't know about that. They're self-defense." She says, "I don't know what I would have done. But I can tell you I would have been scared shitless." She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peloquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Miu's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Miu wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. I'm sorry, the medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time if he wants to kill him? Why doesn't he slash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Miu believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say, might not be attempts, take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video, because I think it's appropriate, that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful, and that he was being attacked. Okay? That he's never wavered on that. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is. Right? What has persevered through this case is Nick Miu's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin. That has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly, in terms of the burden of proof and what the state has to do, is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things. If there is a pause or hesitation about what you need to do because you're getting information from various places, and you say, I need a break, I need to figure this out. That's reasonable doubt. Okay? It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick Miu, and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Miu home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
Oh, did you see Nick's brother? Look at, he gave a nod to the camera. That's Nick's twin brother. 5-minute break, and then we have a rebuttal. Not 5-minute break, but rebuttal.
As you just heard Mr. Tropsy say, his entire defense is based on what Nick Miu told you during his testimony.
Oh, Dad's up now?
Was thoughts in his head.
Dad, for the rebuttal.
What do we know about Nick Miu? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself he's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up, right? Why would he say that 2 boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say 1 boy pulled a knife, that would be good, but if it's 2, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible? That he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Miu ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Miu's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Maddie Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Maddie Cohen when he's only got 2 girls standing in front of him. After the fight, it's one-on-one to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Miu continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Miu turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on them in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schumann tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made, over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Miu, who, as Mr. Trofsky said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time. A.J. Martin was not armed. He pushed Mr. Miu in the back. We know that. He didn't kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Miu. They made a big deal about Lieutenant Hart telling Mr. Miu in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right? If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about the extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks. Putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No, no, no. You have my full confidence. I know you're going to return a just verdict of guilty and deliver justice to Isaac Schumann and everybody else who got hurt by this man. Thank you.
That's the end of closing. Here we go.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Miu is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nicolae Miu. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schumann, the jury finds Nicolae Miu not guilty. Return only one for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Miu commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted first-degree intentional homicide as charged. Another form, As to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Miu is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict that they have agreed upon, so help you God?
I will. The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict, signed by the foreperson, back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you, so we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The two alternate jurors are Darren.
Good thing they muted when they did.
You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that
Oh, they're giving them licorice.
facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
Stand up!
Please be seated. Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you?
No, sir.
All right. The alternate juror forms, or the alternate, I don't know what you call this, the jurors selected for the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it, you may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
So the clock starts now. So we are
and good
officially in
afternoon from our Fox 9 streaming center. You were watching our Gavel Gavel coverage of the Apple River stabbing trial. This case, Nicolae Miu's fate, now in the hands of a St. Croix Circuit Court jury in Hudson, Wisconsin. You heard there 2 alternates have been set aside. They will not deliberate at this point. One a male. We don't know the gender, age of that gentleman sent home, nor the second alternate at this point. Just waiting to hear back from our crew at the courthouse. Appears Wisconsin does this alternate jury process a little differently than we might be familiar with in Minnesota, where the jurors are just sent home and excused, but they will keep these 2 on standby in case they are needed during what could be a prolonged deliberation, frankly. A lot of charges here, a lot to unpack. The claims of self-defense, a top count of first-degree intentional murder, the reckless nature. This jury has a lot of work to do. With that, let's bring in Debbie Lang, our criminal defense attorney from the Twin Cities, who's been watching this trial, or closing arguments with us today, and has been following the case throughout. Debbie, that's a lot to unpack in that last hour. Defense closed. The state got its rebuttal. It felt awfully personal from Brian Smeestad there, the assistant district attorney, as he asked this jury, and he gets the final word to convict on the top counts, to provide justice for Isaac Schumann and the others stabbed that day. I'm just wondering if you could help us dissect what we've just watched, your thoughts on it.
So obviously the hour began with defense attorney Trophy, and he took a very different approach.
Trophy.
He came in right away, summarized within 5 minutes the relevant facts. And then he told the jury that he was going to give them a map next. So he explained that he was going to go through several points about the law, about subjective beliefs, about provocation, and then discuss proof beyond a reasonable doubt.
All right, guys. So we are officially in the jury deliberation segment of this trial. We have our timer. We're 2 minutes in. Myrtle Beach, that's the thing. If he gets found guilty on a lesser charge, it's still a lot of time. But the judge said that they could not take the punishment into consideration. It's not a Swiss Army, but it's a pocket knife. It's just not that brand. Let me see if I can find a picture of the actual knife. Did we see a picture of the knife? I could have sworn they took it out of the box at one point, didn't they? Okay, here it is. It's not very big. My husband has the exact same knife, I think. It's really not that big. Here it is. I found it. So let's get a picture of the actual knife up here. That's the knife. Y'all see that? That's Nick's knife. It was small. No, it's not a box cutter. Melmo, you're thinking of a box cutter. That's a utility knife. This isn't a box cutter. It folds out. It's like a switchblade knife. And it has that clip because, remember, he said it was clipped onto his pocket in his swimming trunks. Meg P coming in hot with some facts.
Coming in hot, just like the fajita.
There are no legal penalties for carrying or concealing a knife in Wisconsin, regardless of blade length or style of knife, unless you are prohibited from possessing a firearm. And he had no criminal history, so he had every right to have this. That's illegal in Illinois, Paul? Really? It's just not that big of a knife. No, it's not. You're thinking of a box cutter. Like carpeting is cut with a box cutter, like a straight edge. Where it like goes, you use that little thing to make it go up and down. It's not that kind of a knife. Folding lock blade. There you go, Freeman. Over 3 inches. Bridget, I know it's illegal to carry knives in the UK. You guys have instead of gun violence, you have knife violence, right? We just can't forget, though, that the fear made him poop his pants You can't fake that kind of fear. A flick knife? Oh, maybe the timer doesn't start then. Well, maybe I should pause it. You're right, Brand. They might deliberate while they're eating. He didn't say they weren't, so we'll keep the thing. Let me check Court TV. They always have the clock up. Let's check Court TV's stream here. Are they even streaming this today? No, they're doing Daybell. Maybe Law and Crime. That girl from Wisconsin too, the Slenderman thing. No, Law and Crime does not have the thing up. So maybe they're not deliberating yet, but it sounded like it. That is so weird, Meg. Hey, Andrew. I have a feeling that the jurors might have a lot of questions when it comes down to it. Maybe questions about, filling out all these different papers and things like that. You guys want to do a poll on how long for the verdict? Yeah, the Slenderman thing is... Hang on. It has an event for today. Let's see. We have Brian Koberger tonight at 7, too. I don't know why this girl's back in court. This Anissa. I swear I saw an event for today. Wisconsin is off the chain. Look at Law and Crime used to be called Law News Network. Now I don't see it. Anyways, she's supposed to be back in court. Law and Crime did have something up. But now I don't see it. Did she have like an evaluation done or something? Anissa Weir. Law News. Look, Law News Network. Court TV does have a clock. It's at 10 minutes now. Okay, they do? So mine's not too far off. We'll just leave it. Here it is. 2 o'clock. In 20 minutes. See? Oh, the other girl is already out. Weir is out. This is the second girl. She's arguing for her release, I guess. Let's see if we've got anything. I think I had something saved to watch later. Oh. Did y'all hear about this horrible lady who freaking threw her infant into the highway in Los Angeles? So, in LA yesterday, this mother stabbed her boyfriend to death, then took her 9-year-old and her 8-month-old in the car with her. The 9-month-old was being held by the 8-month-old was being held by the 9-year-old, And while they were on the freeway, she pushed them out of the car and the baby got run over. And the 9-year-old was able to make it over to the side. But can you imagine the 9-year-old? The 9-year-old witnessed her mother stab the boyfriend. And then the 9-year-old lost grip of her baby sister or brother and saw that baby get run over by numerous vehicles as she or he made it over to the side of the road. It's horrific. And then the mother went and she was driving a Porsche and she crashed it and killed herself. She's dead too. Watch this shiz.
Of deaths across Southern California being investigated tonight. 3 people dead, including an infant on a busy freeway.
Police still trying to learn tonight if they're all connected. First, a man was killed in a Woodland Hills apartment. Then a baby found dead on the 405 freeway in Culver City. And finally, a woman pronounced dead in a Redondo Beach crash.
And KKL News reporter Lori Perez is following this case for us tonight. She's live in Woodland Hills. Lori?
Pat and Juan, you're right. This is a horrible story that started on the 5th floor of this apartment complex behind me, the start of a trail of violence and tragedy.
A little after 2:30, something I wasn't really looking at the time. I just heard a lot of loud arguments between a couple.
This neighbor, who prefers to stay anonymous, says it was a very bad fight he heard coming from a 5th floor unit in these Woodland Hills Montecito apartments early this morning. But nothing prepared him for the depth of tragedy it apparently led to. Police say a woman stabbed her husband to death and then drove away with her 2 children. Neighbors say they saw evidence of trouble first thing this morning.
When I drove out the other gate, I saw that the first gate had been bashed out, like somebody had hit it with a car from the inside. So I knew something weird had happened.
Just before 4:30 a.m., drivers in Culver City started calling police after spotting 2 children on the freeway. 911 got multiple calls about a medical emergency on the 405. Responding officers say they found a baby, thought to be no more than 6 months old, dead in the lanes, and a 9-year-old little girl on the side of the road with moderate injuries. Alone, no adult in sight. Witnesses reported seeing a dark sedan on the scene at the time of the incident, but when CHP arrived, the car was already gone.
Everything's still under investigation as to how they got there in the first place. You know, it's a very unusual incident, how they can just appear there.
It remains unclear how the children got out of the car, whether they were pushed or fell out, and whether they were hit by any cars or if their injuries occurred earlier. As that investigation was just beginning, at 5 a.m., Redondo Beach police were responding to this single-car crash into a tree on PCH near Vincent Street. Paramedics pronounced the woman driving dead on scene, and tonight police are investigating whether she was the mother and wife involved in the earlier incidents. Neighbors are reeling from the developments.
They were cool.
So she was going through a divorce from someone else. So the guy that she stabbed, I don't think is the guy she was divorcing.
People, I met them. I didn't know them by their names, like really close, but you know, just a hi and bye. Seemed that everything was okay with them, and I met their newborn a couple of weeks ago. Congratulated them. Just a very bad day. I mean, I wish the kids had a chance.
We're told the little girl was taken to the hospital for treatment. We are live in Wood.
Isn't that awful? Can you imagine that little 9-year-old will never, ever be the same? Never be the same. Here's another video for you guys from Miami. We watched someone drown last week during spring break. This is an unconscious man pulled from Riptide off the Florida coast. Y'all gotta be careful when you come down here. You can't fuck around with the ocean.
Actually going to head to the central east coast of Florida. A story there of survival out of New Smyrna Beach. An unconscious man was rescued from the ocean last month. It was all caught on camera.
And Pamela Cohen has more to say on the efforts that really tried to save his life.
A visit to New Smyrna Beach almost ended one 21-year-old's life.
The first thing he said is he's never going to the beach again.
Deputy Stan Manhart was one of the first responders on the scene the day Felipe Ribeiro de Souza got caught in a riptide. Several people were rescued March 30th. Ribeiro de Souza was the only one who was unresponsive. 2 boogie boarders pulled him out of the water. They put him on their board until lifeguard Dalton Smith reached them.
We just let them know that they needed to hold his head up above water, and we just swam them all in together.
Before they even reached the shore, Manhart began CPR.
Sorry for the rushes.
And while still on the board, deputies were trying to save the man's life.
With the patient being slippery, the board being wet, they were able to maintain the patient on the board and doing very effective CPR.
Eventually, Ribeiro de Souza was handed off to the New Smyrna Fire Department, and they still had the tough job of getting his pulse back.
With saltwater drownings, what happens is when the salt water enters the lungs, you have a major fluid shift in the body, so that it creates pulmonary edema. So this patient needed advanced life-saving airway procedures.
Ty Tarno with New Smyrna Fire says the victim didn't have a pulse for 6 to 7 minutes.
It was just a miracle that this young man was able to pull through.
All 3 departments worked together seamlessly.
You're only as strong as your weakest link, and there was no weak links here.
That is just amazing what they were able to do there.
They saved his life, but you got to be careful. People go out way too far. I see it all the time. They go out way far and they think, oh, it's like a sandbar. Like, dude, you're not in Lake Michigan. You're not in Lake Huron. You're not in your freshwater lakes. You have to be careful. Kristen, your messages are fine. You might want to like exit YouTube and refresh it. It's been messing up lately. Yeah, so let me see. The other one I wanted to play for you guys is a hit and run. And this is from yesterday as well. Let's watch this.
There it is. There it is. Okay, now I need to take a deep breath. You guys got us, right? Thank God.
Hit and run driver they're chasing.
I know. I got to catch my breath. I just wanted to get here.
Right, but people think they can go out to the sandbar. You don't have the sandbar like you do. Like the rip currents are stronger out when you go further out. There you go, Trey. He went to YouTube apps, then YouTube.
Well, I can tell you it's been a very
cache.
dangerous and extremely fast pursuit. They've been chasing that van right there. Now, the original want, I can't tell you. But since we have been listening to it, making an effort to get here, this vehicle has crashed into several deputy vehicles, has almost hit a couple of...
What happened?
On sidewalks, and now you can see it. We're on the freeway. Let me bring up that speedometer for you so everybody can keep up and watch. They're over 80 miles an hour. Now, what the original want is, I don't know. And also, I have to put it out there, we don't know exactly who is behind that wheel.
Some music
now,
for this.
They actually have said the words her a couple of times. I don't know if that is a female or it's just a, they're just saying her like that van. But the sheriff's helicopter overhead been making the calls, and this vehicle has been extremely reckless. This is probably the most, the longest it's been going in one direction since we've been listening to it. Getting up here onto the freeway, this vehicle was on streets for the longest time, and again, had made contact with several vehicles, and most of those deputy vehicles, meaning smashing into them as it was continuing to flee out here. Right now, we're getting into the Commerce area. Now we're on the southbound 5 freeway.
Wait, what is that hanging on the side of that van? Can you make it out? Is that just a part of the mirror?
I would say that's it's probably the mirror.
Okay.
I would venture to say that that's the mirror that we're seeing right there. We can stay on these tight shots. It's just at these high speeds, and the fact that this van has collided with so many other vehicles, I'm just going to get a little bit wider just in case something happens. And also, when this does come to an end, don't be too surprised if we stay with a much wider shot, because this vehicle has several assault with a deadly weapon on multiple deputies out here. That vehicle's slowing down a little bit, doing some swerving. That's probably because it's getting blocked. But again, you can see the sheriff's deputies are behind it. I believe that's going to be East LA in the lead. The sheriff's helicopter overhead. But original want, I'm not sure if our assignment desk can pick that up. That is really what I'm curious about. I don't want to give away too much, but I can tell you that there's actually another agency's helicopter nearby up high. I'm
What you are witnessing is real. The participants are not
to make a
actors.
traffic stop on it, and originally what this person might have been wanted for. You can see that driving on the wrong side of the road right there, and the speeds are continuing to pick up.
This is so dangerous, and it's interesting, this vehicle we're looking at, it almost looks like a work-type van, but obviously it could just be somebody's kind of van that they use as well besides work, but it's also kind of interesting. We're looking at the driver making weird motions with the steering wheel. I don't know if their steering is kind of out of whack, but constantly going like very little movements left and right. It's just, we don't really see that often.
I'm not sure if that, we just took a peek in there. I'm just going to say that that's a guy driving that van right there. But, maybe this is because of that person's demeanor. Maybe they're not all there with us right now, but or possibly it has something to do with the van. Like I said, it has made contact with several deputies' vehicles and some other vehicles as well. So maybe there's a little bit of damage to the mechanism right there. I'm going to go a little bit wider, just down.
Oh, it's freezing.
Well, but you can see that van continuing to drive very recklessly, went through a red light right there, and it's continuing on. We made our way into the Southgate area now, and our assignment desk just saying the original want on this vehicle, is just going to be reckless driving, and that seems to continue.
Yeah, definitely this individual is driving recklessly, that is for sure. We see that the window went up. It seems like that person rolled the window up. You mentioned sheriff's deputies following this vehicle. What other agencies do we know of that are on the pursuit of this vehicle?
Right now, it is just going to be the sheriff's department. You can see one of their black and whites getting much closer. Now, are they going to try to pit it? Are they? I think they actually tried to block this van in at one point at that traffic circle in the city of Commerce over there, very near the Citadel. And the van, like I said, basically wiggled its way out or rammed a couple of officers' vehicles to get out of the way. 70 miles an hour on surface streets out here. This is, excuse me, my voice is cracking because I really am having a hard time just watching what is going on here. Gage is a major road, if there's no doubt about it. You can see and traffic seems to be light. But again, at those high speeds, anybody comes up on a red light or anything like that, this could become very tragic very quickly. But you got an idea what the sheriff's department is dealing with. This is a very dangerous individual, and of course, the officers or deputies are trying to get that vehicle to stop safely. And the only thing they can do right now is lights and sirens, keep behind it, and just hopefully that the public hears those sirens before that van gets too close.
It's not very busy down below, though. I am noticing that the surface streets are a bit wide open, which is good, given the circumstances.
Very good considering the circumstances, because when we watch these things, law enforcement, look at that wrong side of the road right there again, and speeding up. This is just, it's so difficult to watch sometimes. Continuing on, you have some road construction coming up. I wonder what that is actually going to be. Getting into that left turn lane. Are we making a left turn? Nope, we're going to stay straight, cutting that person off. And these are the types of maneuvers that all law enforcement, when they're down there, they actually do not want to see this. Believe me, they want to bring these things to an end safely. And when these drivers do these ridiculous moves that put so many people in danger, including the driver of that van, this is when it becomes such an issue on, are we going to stay behind it? Are we going to stay in pursuit? What's going to go on?
Stu, we actually have Gigi on the ground with more information on this pursuit. Gigi, what do you know?
Well, this pursuit has now been going on for about 25 minutes. The driver of that white transit van, believed to be a female, is wanted for a hit and run. She is believed to be under the influence. Now, LA County Sheriff's deputies have been pursuing her through East LA. This has been on and off the street. She has had multiple misses with deputies, and we understand she may have just ran into a deputy. An ambulance has been called to treat that Los Angeles County Sheriff's deputy. Now, the Sheriff's Department is in contact with the California Highway Patrol, who may soon be taking this pursuit over. This pursuit, given the severity, the nature of the charges this driver is now facing, will not be canceled. We're talking about hit and run. We're talking about multiple narrow misses with pedestrians. At one point, one deputy, the chopper was above tracking. We're talking about the sheriff's chopper, of course, was tracking this pursuit and watched as the driver appeared to intentionally drive towards a sheriff deputy in their patrol car, narrowly missing them. That deputy got out of the way, but again, an ambulance has just been called for another deputy. Now, speeds have been kept to about 45 to 55 miles an hour, but this is extremely dangerous because this driver not only is suspected of being under the influence, but we've watched as she has run multiple red lights, has narrowly hit pedestrians that were crossing the street, never slowing down, never stopping for them, narrowly missing them. This is extremely dangerous, and this suspect, again, wanted. If you're just tuning in to Good Day LA, this pursuit started in the East Los Angeles area with the Los Angeles County Sheriff's Department. The driver is believed to be a female. Right now, they believe, and you can see it appears that her driver's side mirror is now hanging down, and that just shows you that she hit something. Earlier, we got several reports that she had hit several other cars, innocent people, during this pursuit. And again, an ambulance call. Now, you see she's turning into a driveway right now, and she may just get stuck here right now. She is turning into a driveway. Stu in Skyfox has a better view. He is above it all. Stu, I'll let you take it right now.
Thank you, Gigi. Thank you for that information. And taking a look at this, that was just a laundromat. We just went right through that laundromat, continuing on, and the Sheriff's Department still right behind it. Those deputies are keeping as close as they can. Lights and sirens, just trying to warn the public about what's going on. There's the sheriff's ship. That's the one that's down low. That's the one that's going to be keeping the eye on that vehicle. You can see they're now going into another parking lot right there, making their way through. This van has actually used a lot of parking lots in the past, which is very dangerous because, you know, these are stores. People are basically looking for parking, not expecting somebody to be barreling through there at speeds of 30, maybe more miles an hour into another parking lot as we continue on. As far as the units on the ground, the deputies, they have backed off right now. Sheriff's Department, they are up above it. You can see that sheriff's ship right there. And a near miss again, making their way through another one of these parking lots out here. I would venture to say this is probably going to be a supermarket. That one I wouldn't say close. That pedestrian didn't even know what was going on. Back out onto the major road out here, and the pursuit continues. Very dangerous this afternoon. There is no other words for it. If you know somebody that might be in this area, like on Slauson or in the Southgate area, I would just kind of get a hold of them and just make sure that they know that this is going on in their city. That van, we've seen it in the past. Sometimes these pursuits, they pick up a pattern, and then they just kind of drive around in these areas. This one just continues on. We haven't seen him make a turn through the same neighborhood twice, but parking lots, that seems to be the spot that this van really likes. And every time this happens, my blood runs cold. You've got people walking down there, and again, you just don't expect somebody going 30, 40 miles an hour when you just parked your vehicle and you're walking into a store or coming out of a store and going back to your vehicle. Hopefully it's going to pop out. There it is, right out the other side. But this van continuing on this morning, and again, we heard the Sheriff's Department talk about it, calling it a female driver, and also we heard that Gigi say it as well. This is an interesting one. Into a loading dock area. I'm gonna have to work with Mike a little bit. You keep coming to the right. Keep coming to the right. And it looks like deputies are running up to the van, just trying to get that door open. That's really what we need to see. Not even that person running into this building out here. We'll get that address for you, but thank goodness thank goodness this thing is coming to an end right now. That van stopping and that driver running inside that building. We'll see if we can get a little bit lower and perhaps look inside that warehouse, see what we can see. But look at the number of deputies. And again, this is not an over response at all. And I'm going to just kind of make sure that they don't come running out the back. I have a feeling this person does not know this building. This was just a random stop. And let's see if we can see inside. But right now, we know those deputies ran in there. Let's see if there's a back door or something where this person's coming out. And I'm sure that the officers are concerned about other vehicles in the area, maybe another delivery van. We don't want to see any kind of carjacking. But right now, I'm listening to hear them say if this person is in custody. I have not heard that yet.
Not to mention,
walking out.
Yeah, not to mention the employees in that facility right there, that warehouse where it looks like there's a lot of merchandise inside. But you're looking at the end of a pursuit right here at Bickett Street at East 54th in Southgate, East LA, where sheriff deputies have been in pursuit since 9:45, pursuing this white van you see parked there, and the suspect, a female driver who is apparently intoxicated, running into that warehouse, and deputies on alert, going inside, trying to detain that person who is wanted for hitting a number of vehicles, including a sheriff's deputy, intentionally, it looks like, in all of this. And of course, we'll stay on top of this. But for now, let's go to break. Yeah, what happens? Hopefully, sheriff deputies are inside and can take this person into custody. Stu, what do we know?
We don't know that yet. That's what I'm still listening to. I haven't heard the words code 4. You see some deputies getting out of that, walking out of there, and they are checking that van. This is the standard procedure out here. They're going to pop the doors, make sure that there's nobody inside that van other than that driver. My pause right there as I'm listening to the scanner. I want to hear if the deputies say they have this person into custody. I just heard some deputies very out of breath.
Okay, Stu, why don't you take a listen? While you do that, we're going to check in with Gigi. As we're watching, it looks like employees evacuating this warehouse, whatever this business is. They're walking out right now. So, Gigi, what do we know? What are you hearing?
What is the business?
Roxanne, we're also hearing code 4 that the suspect is in custody. Now, what you're watching live right now is the LA County Sheriff's Department clearing that white transit van that was involved in a...
So they caught him, but what's the name of this biz? Takiokaya? What's that? T-A-K? Let's look. T-A-K-A-O Kaya. T-A-K-A-O Kaya. It's a city in Japan, so it's a Japanese company. Taco Kaya USA. What the fuck are they making in there? Green tea and shit? Look. Green tea, nori, seaweed things. Soy crepes. So they're in there making fucking seaweed wraps, and this dude's breaking in on a freaking police chase. They come out in their lab coats. Oh man, all right, we're in deliberations still. Let's go back over to Fox Local and listen to some of Miu's testimony while we wait.
Foot.
Okay.
Less than a foot.
You've heard it described through trial as in your personal space. Would you agree with that?
Yes, right in my face, I would describe.
When that was happening, what did it sound like to you?
The volume was very, very high.
Let me ask you about how your body was responding in that moment when people are pushing you, poking at you, the volume is high. How's your heart? Could you tell us about what your heart rate was?
Oh, yeah. My heart rate was getting really high. My breathing was getting very high. I was...
How about your vision? Did you have normal vision in that moment?
No. At that moment, because of the situation, I was getting tunnel vision.
And can you describe what you mean by you say in tunnel vision?
I couldn't see peripheral vision, but I could see center and right before my eyes.
How about hearing? Could you hear the noises?
I could hear the volume very high, but I couldn't understand what they were saying. The noise became garbled. I mean, the sound became garbled.
Did you feel threatened at that point?
Yes.
Did you have your knife in your right hand?
Yes.
What did you do with your left hand? Tell us what you did with your left hand.
Yeah, with my left hand, I pushed her away from my face.
Can you show us what you did with your left hand? Why'd you do that?
She was very close to my face. She was in my personal space. She had been there for a while, and I felt threatened.
Did you intend to harm her in some way?
No.
Did you try to harm her in some way?
Absolutely not.
Do you know where, if at all, you had contact with her body when you raised your left hand in that manner?
No.
Do you think you had contact with her?
No.
Okay. I want to take us out of that space now for a second, okay, Nick?
Okay.
If I could have the screen again. You were here in court when we talked about, when we watched the video of you speaking with Brandy Hart, is that right?
Yes.
And I think you told her about your health condition. Can you just tell the jury now, what was your health like on July 30th of 2022?
It was very poor.
Okay.
Yeah.
Had you, I think you mentioned to her again, had quadruple bypass surgery before?
Yes, sir.
And when did you have that?
2020, about the same month, so about August.
Showing you here what's been marked as exhibit number 108. Can you tell us what those are pictures of, starting just on the left?
Yep, on the left it's me right after the surgery, holding a red heart pillow against my surgery.
What was the purpose that you knew of for that red heart pillow?
That was to protect my surgery from hits, bumps.
Was that something that the hospital provided? It looks like there's like almost a picture of heart and lungs on there.
It is. The hospital provided that.
And then the picture in the middle, what is that?
My first walk, my new life.
Did it take you some time to recover and be as active and mobile as you were before?
Oh, yeah.
Do you think you ever reached the same level of mobility and fitness that you were prior to the quadruple bypass?
Never.
What's the picture of you on the right there? You can tell us.
My baby.
Okay. Is that a dog?
Yeah.
Is that dog important to you?
My angel.
Okay. And that's the cushions helping you to enjoy time with her, but still keeping your chest safe?
Yes, sir.
Okay. You've had other surgeries in the past, is that right?
Yes.
Did you have a hernia surgery?
2 hernia surgeries.
Have you had back surgery?
Yes.
And again, in general, would you consider your fitness on, if you were going to put it on a scale for July 30th, what would you consider your overall health and fitness on July 30th of 2022?
With my weight and very poor.
I want to ask you now about moving on to the Apple River on July 30th, okay?
Okay.
On that, this was a planned trip, is that right?
Yes.
Did you get a call from your friend Ernesto sometime before that trip?
Yes, sir.
What was that call about?
He wanted to remind me to bring my knife to cut string when we tie the tubes together.
Okay, when you say, do you have a pocket knife?
Yes.
Okay, can you tell us about that pocket knife?
I owned it for about 10 years. I have it a lot on me. I use it as basically a dual tool. I call it my Swiss Army knife, basically because I use it as a screwdriver. I cut insulation when I do electrical work. I use it pretty much everywhere.
Okay.
I'm an engineer. My tool.
Is it something that you've carried on your person, I don't want to say all the time, but somewhat routinely?
Yeah, when I knew I was going to work on something or need it for something, yes.
Okay. Now I want to skip ahead again now to the river, okay? At some point, did Ariel lose his phone?
Yes, he did.
Did you go to look for that phone?
I volunteered to go look for it.
When you went to go look for that phone, what were you wearing?
Before that?
Nope, right when you left your group to go look for that phone, what were you wearing?
So I took my goggles, my snorkel, and my swimming trunks.
Did you have anything on your feet?
Yes, I had, on my feet, I had a pair of really, really torn up sandals.
Can I approach, Judge?
Yes.
Showing you what's been marked as Exhibit 113. Is this a packet of 9 photos of your sandals?
Yes.
You've seen those?
Yes.
Does that accurately show the condition of the sandals that you had?
Yes.
Can you just move for the admission of Exhibit 113?
Any objection?
I don't think I've seen them, Judge, if I can take a look at it.
Yes.
Oh, pardon, never mind, this guy hasn't seen them.
All right, 113 is received.
These weren't taken by you, were they?
Pictures? No.
All rise. Okay, thank you. Please be seated. The court will call a matter of State versus Morgan E. Geyser, 14 CF 596. Appearances.
The State by Ted Sapakowicz and Abby Nicolae.
Okay, thank you and good afternoon.
Good afternoon. Judge, also here by Zoom are the parents of the victim in this case. I know we just have one on the screen, but I believe both are observing by Zoom.
All right, thank you. Are there other victims present in the court? Family members?
Yes. They're seated here, Judge.
All right, very good. Thank you and good afternoon all. Further appearances.
Good afternoon, Judge. Attorney Anthony Cotton and Bradley Novreski here with Morgan Geyser. She's been produced in person.
All right, thank you and good afternoon. And thank all for your courtesy in that we're starting later due to some issues that the court had. So I appreciate that and thank you for that courtesy. We're starting a half a day late, so we'll continue until tomorrow. We had the hearing initially set for 2 days, and if it will go into tomorrow, but if it takes longer, we'll conclude the hearing. We'll go further than that. We won't reschedule that portion unless it's necessary for purposes of making a decision. I just wanted to note in beginning that to give some history in the case so it's clear as to what brings us here. The offense occurred in this case on May 31, 2014. Ms. Geyser and Ms. Wire were both defendants in the case. All parties, the victim as well as the defendants, were very young at the time. Ms. Geiser was born on May 16, 2002. On October 5, 2017, Ms. Geiser entered a plea of guilty to count one of the information which alleged attempted first-degree intentional homicide party to the crime. There was an enhancer that was struck at the time. The enhancer was used by use of a dangerous weapon. By stipulation, the court accepted the various reports that had previously been ordered and received, and the court found the defendant first guilty she entered a plea to the charge, and then not guilty by reason of mental disease or defect based upon the reports that had been received. The court then committed her to the Department of Health and Human Services for preparation of predisposition reports. Reports were received and read, and then the sentencing hearing took place on February 1, 2018, at which time the court committed Ms. Geiser to the Department of Health Services for 40 years, finding that conditional release of Ms. Geiser would pose a significant risk of bodily harm to herself or of serious property damage. Prior to today, Ms. Geiser has filed 2 petitions for a conditional release, which were withdrawn before a hearing was scheduled, before a hearing took place. Ms. Geiser filed a current petition on January 17, 2024. As a result of that petition filing, the court ordered Dr. Brooke Lundbaum, Dr. Deborah Collins, and Dr. Kenneth Robbins to prepare reports. Those reports have been received and been reviewed by the court and read and reviewed by the parties. The court also received a letter report from the Department of Health Services at the Winnebago Mental Health Center that was dated February 20, 2024. The court has also received a brief and supportive conditional release as well as a proposed conditional release plan filed by Ms. Geiser's attorneys. Excuse me. Petitions for a conditional release may be filed after 6 months of the initial commitment petitions for conditional release may be filed after 6 months of the initial commitment to institutional care, requesting the court to modify its order of institutional placement to conditional release, which is what the subject of today's hearing is. The state has the burden of proof by clear and convincing evidence that the commitment should continue. With that, then, I'm prepared to proceed. Now, as I indicated, the state has the burden. Does the state wish to go first, or does Ms. Geiser's attorneys wish to go first?
I believe the state should go first, Judge, given that it is our burden, and I'm prepared to do that.
All right, then let's proceed.
The state would call Dr. Deborah Collins.
Yes, there's no need to sequester any witnesses, true?
True.
All right, very good. Dr. Collins, come forward. You have a seat behind the court reporter. When you step up, they'll stay standing. Raise your right hand. Our clerk will, you can step up. Our clerk will swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Very good, thank you. Then the microphone is the bar with the red light on it. Just speak directly into that. Good afternoon.
Good afternoon.
Good afternoon, Doctor. I'm going to show you right away what's marked as State's Exhibit Number 1. Ask if you can identify that, please.
It's a 9-page copy of my professional resume.
You are a doctor, correct?
I'm a doctor of psychology, yes.
Okay. Can you tell the court your educational background prior to becoming a doctor of psychology?
In 1987, I was conferred a Bachelor of Arts degree from St. Norbert College here in Wisconsin.
In 1992, I received a Master of Arts degree from Boston College. In 1995, I received a Master of Arts degree in clinical psychology from the University of Hartford in Connecticut. And then in 1998, I was conferred from that same institution a doctoral degree in clinical psychology.
Would it be fair to say, doctor, that most of your professional career has been spent, however, in forensic psychology, or how would you characterize it?
Almost the entirety of my professional career since licensure in '99 has centered on forensic psychology.
And how does your doctorate in clinical fit into a career in forensic psychology?
The doctoral degree in clinical psychology is a generalist degree, if you will, and then I began to specialize in a subspecialty area of psychology late in my career, late in my education, if you will, so around 96, 97, and then pursued eventually board certification in the field.
Why did you choose the area of forensic psychology?
Because of the interest that I had in the areas, in the area where law and mental health intersect.
In addition to your doctorate in clinical psychology, do you hold any licenses or other professional, qualifications?
I'm licensed as a clinical psychologist in the states of Wisconsin and Michigan currently. Additionally, in 2005, I became board certified by the American Board of Forensic Psychology, and that's a credential that's held by about 370 psychologists in the nation.
And I'm sorry, when did you become accredited?
2005.
You're also a business owner, correct?
Yes.
And what businesses do you own?
I own Behavioral Consultants, Inc.
And you've owned that since when?
I've been a part owner for well over 15 years, and I've been the sole owner since approximately 2017.
And it's a part of that business that is represented by the Wisconsin Forensic Unit, is that right?
Behavioral Consultants is the parent company. The Wisconsin Forensic Unit is a division of that company.
And what is the Wisconsin Forensic Unit?
The Wisconsin Forensic Unit is a division in contract with the State Department of Health Services tasked with conducting competency to stand trial evaluations throughout Wisconsin's 72 counties.
And maybe you can describe for the court how much of behavioral consultants is made up of court-appointed work versus any private work that might be done?
I would say the vast majority of referrals would be court appointments, but there's also 30 to 40% which consist in referrals from attorneys, other agencies, and attorneys from both sides of the aisle, if you will.
And you've been doing all of this kind of work for at least 25 years?
Approximately, yes.
Throughout your career, would it be fair to say that you've done thousands of competency evaluations?
Yes.
And how about mental responsibility evaluations?
I would say a few thousand mental responsibility evaluations, lesser number than the number of competency stand trial evaluations.
And then would it be fair that there's lesser evaluations for conditional release?
Yes, I would say that number is in the hundreds.
And tell the court how you first became involved in the case with Morgan Geyser.
My initial involvement or engagement in the case was through, by being retained by Ms. Geyser's defense counsel.
And when did that occur?
That occurred within a couple of days following the arrest, the index offense in this case.
And that, was May 31st of 2014.
Yes.
So within a few days of that, you were retained.
Yes.
And do you recall when you first met Morgan Geyser?
June 4th of 2014.
And where did that occur?
That occurred at the Washington County Juvenile Detention Center.
Can you describe for the court as much as you recall about your initial impressions of Morgan when you first met her?
My initial impressions included that Ms. Geyser was not well psychiatrically, that she had experienced trauma certainly in the commission of the offenses, and that she also presented as quite odd during the 2.5-hour interview I had with her. So her mannerisms were odd, her expressed emotions were inconsistent, sort of incongruous to what had occurred. At one point, she burst into tears when the threat of her Harry Potter friends not being present to her or coming back was broached.
What did you think when you first met her?
When I first met her, I was collecting data, if you will. I was observing her, talking with her, obtaining information. I wasn't immediately forming conclusions or opinions.
And you've met with Morgan many times over the course of the years, true?
Approximately a dozen.
Okay, and you've authored 7 reports to my count regarding Morgan?
Yes.
And I think we discussed this, but it really wasn't until the first petition for conditional release that you were court appointed, is that right?
Correct. I believe that's accurate.
All of that time being involved with Morgan prior to that first petition for release was as a result of being retained by the defense?
Yes.
Is that unusual at all in your experience throughout your career to have had that much contact with someone?
Over that span of time, almost 10 years, yes, I would say that's unique. It's not singular, but it's certainly unique.
There have been other cases that you've been involved for this similar length of time and perhaps had that much contact with someone?
There have been cases where I've been involved for that length of time, okay, but not necessarily as many contacts for so many different reasons over time.
And in this case, you did conduct a review of mental responsibility with Morgan, is that right?
Previously?
Yes.
Yes.
In fact, I think you authored a report November 2nd of, or thereabouts of 2016 related to mental responsibility.
Yes, November 2nd of 2016.
Okay. So you met her roughly in June of 14 and were asked to conduct a mental responsibility evaluation sometime in 16. So you had roughly 2 years of involvement before giving that opinion on mental responsibility, correct?
Correct.
And describe again for the court ultimately what you concluded regarding Morgan's mental responsibility in this case.
I concluded to a reasonable degree of professional certainty that at the time of the index offense, so May 31st of 2014, she was suffering from a condition which would qualify as a mental disease or defect as broadly defined by the Wisconsin jury instructions. And I also concluded that because of symptoms of that condition, she was rendered to lack substantial capacity to appreciate wrongfulness or conform her conduct to the requirements of the law, and that there was support for her plea in this case.
And what was the mental condition that you diagnosed her as suffering from at that time?
As I recall, the mental condition was unspecified schizophrenia spectrum and and other psychotic disorder.
Do you know at what point between June of 2014 and authoring that report in 2016 that you came to a diagnosis of unspecified schizophrenia spectrum?
I do not know precisely. It was a process, though. It wasn't a conclusion arrived at within a day or a month of contact with her, for example.
Can you describe that process for the court?
That process was careful and deliberate, involved consulting with the permission of counsel, with an expert on early onset psychotic symptoms or psychosis. It entailed use of multiple methods, so psychological testing, review of ample collateral records, including discovery material, mental health records, and then collateral interviews with each of Ms. Geiser's parents in person, and review of additional family medical records.
Had you been involved up to that point with anyone this young who perhaps would be diagnosed with schizophrenia?
I don't recall.
But at least this was unusual to you that someone this young could be suffering from schizophrenia?
That someone this young could be suffering from psychotic symptoms and a psychotic spectrum disorder, yes.
I'm going to ask this because it's going to come up later, but I assume prior to doing that mental responsibility evaluation, you considered whether or not there was any malingering or falsifying of symptoms that were noticed with Morgan.
Yes.
And what was your conclusion then regarding any such malingering?
My conclusion was that the totality of information available weighed contrary to identifying her as malingering or faking or misapplying symptoms of psychosis at a time when she didn't have those.
After that mental responsibility evaluation in 2016, when was the next time you had contact with Morgan?
The precise date, I don't know. The occasion was for the purposes of the conditional release evaluation that followed her commitment to DHS and petition in 2022.
And the next report you had authored to the court was the one from August of 22 regarding conditional release.
Yes.
And just, well, briefly, what was your conclusion regarding the issue of conditional release in 2022?
It was my opinion, to a reasonable degree of professional certainty, that there was not support for her safe release to the community or her petition at that time.
And I guess I would ask if you can describe the process that you used to make that determination at that time, including the things you reviewed and considered.
In addition to, again, a clinical interview with Ms. Geiser, so direct contact with her, I also reviewed years of mental health records that had accrued during her treatment at the Winnebago Mental Health Institute. I reviewed the underlying complaint, and I also reviewed my records with my office pertaining to her.
And those records consisted of your work, but also the work of Dr. Lundbaum?
Yes.
And you became aware that after authoring your report in August of 22 that Ms. Geiser withdrew her petition for release?
Yes.
And you were next contacted in this case approximately a year later, again on the issue of conditional release?
Yes.
The process and the information that you described, you reviewed for the August of 22 report, is that similar to every conditional release evaluation you're asked to make?
Yes. At least those types of information and sources are obtained. I believe in the context of the second conditional release evaluation, so 2023, I believe I also consulted with her treating psychiatrist. I would have to check my notes to confirm the accuracy of that memory.
And that would have been a psychiatrist at Winnebago?
Yes.
So sometime in the summer of 23, you're again contacted and asked to do a evaluation regarding conditional release.
Yes.
And what did you do regarding that?
Are you asking for my methodology?
Sure.
I'm now going to refresh my memory for my report with the court's permission.
Which you may do.
For the 2023 evaluation, I met with Ms. Geiser for an hour and a half in-person interview at the Winnebago Mental Health Institute. I reviewed the criminal complaint. I reviewed her records with the Winnebago Mental Health Institute with emphasis on those that had accrued in the interim between the 2022 and 2023 evaluation. I also reviewed a 16-page, at that time, wellness recovery action plan, which Ms. Geiser provided me with a copy of that she had developed. I reviewed her records with our office. I reviewed her records with the Wisconsin Forensic Unit. I also, on July 25th of 2023, had a brief collateral telephone contact with her treating psychiatrist, former treating psychiatrist at that time.
Did you, as part of that report, make your own diagnosis of what her mental state was at that time?
Yes.
And what was your diagnosis on the August of 23 report?
Again, refreshing my memory from my report. Post-traumatic stress disorder, social anxiety disorder, and unspecified schizophrenia spectrum and other psychotic disorder.
Do you know why there was still a diagnosis of unspecified schizophrenia disorder at that time?
At that time, I flagged it history of that condition because I think and still believe that it's important in terms of her diagnostic formulation to acknowledge that for most of the time, since her admission, since her NGI acquittal in this case, she's been identified with a psychotic spectrum disorder and treated for the same.
Well, did you believe that she still carried that diagnosis at that time? Or was it just that there was a history of it?
I was certain that there was a history of it. I acknowledged in my report the diagnostic conundrum that had been presented by this case in the interim between the 2022 evaluation and present.
And what is that conundrum that was presented?
The conundrum occurred in the fall of 2022 when Ms. Geiser told her treating psychiatrist that she had never heretofore suffered from psychotic symptoms, but rather that she was faking those or mimicking those from others in order to, and that she had begun to do that immediately following the offense in this case, the index offense, and that she had done that to assure that the home in which she was sexually abused by her father repeatedly was one to which she would not be returned, and that she would stay in a mental health institute.
What did you think when you were presented with that information of her indicating she had never experienced psychotic symptoms?
What I acknowledged in my report, again, is that diagnostic conundrum. What I also knew is that in the wake of disclosing that she had never suffered psychotic symptoms, or her perspective in 2022, she underwent a significant treatment change. Withdrawn from her treatment was an antipsychotic medication, and in the wake of that, medication change, so in the fall of late 2022, through the time I met with her, she had exhibited no objectively noted recurrence of psychotic symptoms.
And did you have concerns regarding her presentation or her indicating that she had never suffered from psychotic symptoms?
Yes.
What was your concern?
My concern is the accuracy of that perspective that she offered in 2022 to her treating psychiatrist, and why she offered it. Because the overwhelming amount of medical records that were accrued for the many years preceding that pointed in the direction of bona fide psychotic symptoms that Ms. Geiser was experiencing.
And why is the accuracy of her self-reporting important?
Because psychotic symptoms are essentially a private phenomenon. The rest of us don't hear the voices if someone's hearing them. The rest of us don't hold the delusional beliefs someone holds. And they're not tangible. And so one source of information necessarily or ideally is the person experiencing those symptoms himself or herself or themselves.
Is it fair to say that in considering whether or not she's suitable for release, you also have to have some ability to trust her self-reporting?
Yes.
Why?
Again, because psychotic symptoms are private phenomenon in part. And so for Ms. Geiser, psychotic symptoms elevated her risk for violence. So certainly one would want to know if those in fact exist, despite what is or isn't observable by others. Because you're appraising essentially her risk for future violence.
Was she offering any explanation, either to you or in any of the records you reviewed at that time, why this underlying offense occurred?
She has maintained that it had to do with the delusional, my word, delusional, or characterization of imperative of becoming a proxy for Slenderman and avoiding her family and her co-defendant's family from being killed.
But wasn't she now claiming that none of that was true, that she didn't really believe that at the time the offense occurred?
No, it's not that she said she didn't believe that. It's that she said that wasn't accompanied by psychotic symptoms. She described it more like a fanciful belief of a 12-year-old who had been from an abusive family.
You ultimately concluded in regards to that August of 23 report that she was still not suitable for release, correct?
Correct.
Why did you believe that at that time?
Leading up to that evaluation, she continued to struggle with pretty prominent symptoms of anxiety and trauma-related symptoms that were concerning, despite the apparent absence of psychotic symptoms. It had also been relatively recent that she had made that serious suicide attempt in 2021. Additionally, concerning at that time was whether she could sustain her level of functioning in the long term, given the recency of the medication change and the history of this case and the lengthy history of the symptoms that she had labored under.
Let's talk a little bit about that suicide attempt in 2021. How did you become aware of that?
Both from Ms. Geiser and from the record.
And so you actually talked to Ms. Geiser about it?
Yes.
And what was discussed between you and Ms. Geiser about it?
What she told me is that she had attempted suicide by placing a cord about her neck. She had been given some instruction or tips on how to do it, so to speak, from another patient. She made the suicide attempt at night when her roommate was asleep, and it was quite serious. As I recall, she told me that she had broken blood vessels in her eyes, for example. She had exited her room and staff immediately intervened after she attempted suicide.
Was her exiting of her room to try to get help because she couldn't free herself from the cord she had put around her neck?
I believe so.
And staff ultimately had to cut that cord to free it?
I believe so, yes.
And there was some significant injury as a result?
Yes, it's described in the record, and in fact by Ms. Geiser herself, as a serious attempt.
At least between the offense on May 31st of 2014, there had been no attempt to harm anyone until this attempt to harm herself. Is that right?
Not precisely.
Why is that?
There had been other attempts at self-injurious behavior, not suicide, but self-injurious behavior. So previously, at the age of 18 or 19, for example, Ms. Geiser had swallowed batteries, for example. I believe she was also known on occasion to scratch or cut. Not serious suicide attempts, but those were other acts of self-injury.
And I think I was a little confused in reading the reports. Maybe you can clear this up. Was there multiple occasions of swallowing batteries or just one?
To my recollection, there was only one.
Okay. You did conclude in that August of 23 report that Ms. Geiser did still present a significant risk of harm to herself or someone else. Is that right?
Yes.
And that was the reason you were not in favor of release at that time?
Yes.
And again, after you had authored that report, the request for release was withdrawn?
Yes.
You did indicate some things in that report that you felt you would need to see in order to be supportive of release, didn't you?
Yes.
What were those things?
As I recalled, it was additional sustained psychiatric stability, so a lack of meaning, or in part meaning a lack of recurrence of psychotic symptoms, so a longer period of time when she had sustained that level of functioning. Ideally, that she would be provided more opportunities to exercise the liberty, freedoms that she had, including going into the community, so having experiences which would more closely approximate those she might encounter on conditional release. And then I believe I encouraged additionally more structured activities, employment, for example.
And you addressed that in several points in different reports about Ms. Geiser maybe does not take advantage of as much employment opportunity as she could. Is that right?
Yes.
Can you explain that to the court?
Well, most recently, she only resumed employment and then 1 hour a week in early 2024. And she said told me she wasn't interested in supported employment in the institution, and that she wasn't interested because it just didn't align with her interests and because of some conflicts that she'd had previously. So, for example, she worked in the library and was evidently falsely accused about having a phone by her supervisor and became quite upset, for example. So she's largely out of personal preference, for whatever reason, has not pursued and sustained employment in the institution.
I'm assuming you still think that that's an issue now as part of your conclusion that she not be released?
Yes, I believe it's an issue because of the questions it raises about her readiness and ability to pursue employment in the ways that she says she wants to if she gets granted conditional release. So it goes to the issue of the realistic nature or not of her plans on conditional release.
And at least you believed that you needed to see more of that back in August of 23, and still believe that now in April of 24, right?
Yes, among other considerations highlighted in my report.
So you author that report in August of 23, and you're then contacted roughly sometime in March of 24 to do another evaluation, correct?
Correct. I believe it was late January or early February.
Okay. But in any event, you have done 2 reports in about within 7 months of each other, is that right?
Yes.
And your conclusion now in your, the exact date, March 5th of 24 report is the same, that you don't believe Ms. Geiser yet is ready to be released. Is that true?
On that count, yes, my opinion is the same. I believe I framed it slightly differently in the context of the current evaluation because of the bona fide progress, by all accounts, Ms. Geiser is making toward readiness for conditional release.
Well, tell us, how is it framed in your March 5th of 24 report?
It's framed so that clearly I offer the opinion that as of the writing of my report, it's my opinion to a reasonable degree of professional certainty that the facts weighed contrary to her petition, to her safe release to the community. I also acknowledged the belief, forecasted if you will, that assuming Ms. Geiser continues her current trajectory in treatment, maintains her psychiatric stability, and to develop coping skills, stress tolerance, and her support system in the community, her readiness for conditional release in the coming months will follow.
How do you assess her support system that might be available in the community currently?
Part of it's by what she tells me, and to the extent I can, to determine whether that's corroborated in the medical records or other sources of information.
I know there was some indication in your current report of some reunification with her mom and her brother. Is that true?
I would say reconnection. So she's established a reconnection with them. I don't want to overstate that because I don't know the frequency, the substance of it, but she has reestablished some connection, whereas previously she was estranged for whatever reason from them.
Would it be fair to say that it's too early to assess how much support her mother would be able to provide if she were to be released?
From the information I have, yes. Both how much she would be able to provide, but also how much Ms. Geiser is willing to receive if her mother is willing to provide it.
I know there's some indication throughout what type of relationship is she able to have with someone while she's at the institution?
She can certainly receive visits of some nature, and she can certainly have telephone contact. So relationships mediated through those types of methods, if you will.
Do you know, and I correct me if I'm wrong, I think there was some mention of a relationship with a 63-year-old man?
I believe so.
And do you know the nature of that, whether it was by letters or in person, phone contact?
I believe it was at least phone and letters. Whether or not there were any direct visits, I don't recall.
And I think there was another similar type relationship with someone in their early 40s, if I recall.
I believe so.
Again, similar where this would be letters or phone contact or?
To the best of my knowledge.
I mean, there's not really any ability to have any alone time for her with anyone she may have developed a relationship with, is there?
Strictly speaking, no, I don't believe so.
In the most recent report that you've done, is there also a, and I forget the acronym, but the release plan that she provided for you?
The recovery plan that she provided, yes.
And she talks about some potential future employment or what she'd like to do. Is that right?
Yes, I'm not sure the detail that she went into in that document about that, but that was certainly a topic that we discussed.
Okay, and what did she indicate about that?
She indicated that she had investigated the training and cost associated with it for becoming a certified nursing assistant. I believe she had looked at a program in South Milwaukee or at the south side of Milwaukee. I think she estimated it was $850 and that was something that she might want to pursue. In other contexts, she's talked about possibly wanting to work in a hospital setting, so as a certified nursing assistant. She also, however, talked about wanting long-term to become a writer, and that's been a goal of hers for years. Additionally, she talked about the possibility that she might perform part-time janitorial work, which would not bring her into contact with people, but might be able to occur after hours, if you will. It's something that as a child years ago, she actually accompanied her father, and he would perform janitorial work.
Was there something different in the summer of 23 that she was considering as far as employment, if released?
I don't recall.
Okay. Now, most recently, doctor, with your current evaluation, is there a diagnosis that you attribute to Ms. Geiser?
Yes.
And what is that?
Again, I acknowledged her history of a diagnosis of schizophrenia, unspecified schizophrenia spectrum and other psychotic disorder. I also identified her with diagnoses of post-traumatic stress disorder and social anxiety disorder.
I'm going to show you, doctor, what's marked as Exhibit 2, just so you can tell us what that is.
It's a 34-page report over my signature, memorializing, and dated March 5th, 2024, memorializing the evaluation findings that I reached in this case, and it's accompanied by a cover sheet.
I believe that in this most recent evaluation, doctor, there was also a change regarding Morgan's reporting related to anxiety symptoms.
Yes.
Can you talk about that, please?
Earlier this year, so in January, February, Ms. Geiser underwent an institution-based risk assessment to determine her appropriateness to continue receiving the level of privilege that she receives in the institution and possibly to be granted more. In the context of that evaluation, the best that I could tell from the records, Ms. Geiser disclosed that she had also not truly experienced anxiety symptoms, but rather had said that she did so that she could avoid group therapy.
How do you assess that?
Ultimately, I'm not sure what to make of it. That may, for example, one of the hypotheses that I considered was that Ms. Geiser was possibly saying that so that her diagnoses could be altered, so that the anxiety disorder diagnosis might come off of her formulation, for example. At the very least, what it called into question is her recent reliability as a historian and reporter of her symptoms. And that was what was concerning to me. So the jury's still out, if you will. We're not sure what that means, why she said that.
And again, is it fair to say that the reliability of her reporting is very important to you in trying to determine level of risk that she presents?
Yes, and I would add that she's largely a remarkably reliable informant. So the information she provided me about her history, for example, in the interim between the two evaluations, was mirrored in the record. But about that potential for anxiety symptoms or historic psychotic symptoms, that's the one area she's not been, reports she hasn't been a reliable reporter.
That institution-based risk assessment also included some statements that you found concerning, and I'm talking about October 24th of 2023. Do you remember that?
Yes.
And what was concerning about some statements she made during that assessment?
What was concerning was the content of them and the topic that they referenced.
And please explain that.
Perhaps it's best if I quote the record.
Please.
So the comment she made during an individual therapy session, kind of an emotion-charged individual therapy session in which Ms. Geiser has invested herself. So she's done a lot of work in individual therapy. But the comments that were memorialized in the clinical notes from the session on October 24th included, quote, "How do you think I was able to repeatedly stab my best friend and bitch face," referring to the co-defendant, "thought she was all the brains. I was pulling her along too. I didn't care. I couldn't care. I've never known how to care." End of quote.
That's something that stood out to you in your review of the records, true?
It stood out. I wasn't sure how to put context to it. So I knew, for example, that had been said. I acknowledged in my report that that could have been merely emotion-charged comments made in the face or in the context of therapy, which sometimes happens. For anyone who's been in therapy would know. On the other hand, this is quite recent to petitioning for conditional release and suggests, at least in that moment, a callous perception of herself. She later talked with her therapist about that and put that in terms of a question. So she reframed it and said, how could I have cared if I did this to my best friend? But the recency of it relative to her petition for conditional release, the reference to her co-defendant, and to herself, that was a potential red flag, at least for me.
Enough to give you pause as to whether or not she's appropriate to be released at this point?
Enough when taken in the context of the totality of information in this case, not just in isolation.
Because you indicate in your report that at this time, her release is a challenging call, right?
Appraising her readiness for conditional release is a challenging call, yes.
Why is it a challenging call?
Because of the multiple and several complex case characteristics and the fact that Ms. Geiser is now approaching 22 years of age, and she spent virtually all of her adolescence and much of her young adulthood in an institution. In some cases, in most cases, I would say when I'm conducting a conditional release evaluation, I have a baseline for the individual of how they've functioned in the community as an adult. We don't have that in this case. All we know is how Ms. Geiser functioned prior to the age of 12 in the context of what appears to have been certainly dysfunctional, but also an abusive childhood.
And although all of this, as you indicate at this point, presents a challenging call, your call, at least to a reasonable degree of professional certainty, is that she still presents a significant risk of harm to herself or others and is not at this time appropriate for release.
Yes.
Is there anything else, doctor, that you think the court should know in deciding what to do in this situation?
On balance, I believe my report has captured the salient points at this juncture.
I don't have anything else, Judge.
Thank you. Cross-examination.
Good afternoon, Dr. Collins.
Good afternoon.
Let's start by going back to 2014 when we brought you on board, right? It was the defense, myself, my firm that brought you on board, right?
Yes.
And there were some things that were missed back then, one of which would be the sexual abuse that Morgan was suffering from. Would you agree with that?
I would say it was missed, but not because it wasn't looked for, not because it wasn't, Ms. Geiser wasn't queried about it multiple times, at least by myself.
She was 12 years old at the outset of this case?
Barely, yes.
An 11-year-old who had just turned 12 when this happened.
Yes.
And now Morgan is at a point where she has spoken more freely about the sexual abuse she was subjected to.
Yes.
Tell the court a little bit about that abuse. What is she reported?
She reports that the abuse, the sexual abuse, was perpetrated by her father, and that it goes back, or it started as early as she was forming memories. She reports that she tried to tell or communicate that to her mother, that there were red flags, but those weren't heeded. She recalled, for example, during one interview with me, that she would resort to sleeping on the floor because she knew her father couldn't get down to the floor and back up. Ostensibly, she said she did it to be near her guinea pigs or pets, but it was really to avoid the sexual abuse. She reports that her father watched her shower. She reports that her father was often, she knows now, under the influence of drugs and alcohol.
Right. And her mother was where?
Often at work.
Not in the home to protect her.
Correct. And compounding it is that when Ms. Geiser told her mother did not either heed what Ms. Geiser told her mother or believe her.
So Morgan, when she would report these things within the home, her mom would not believe the things she was saying about her dad.
To the extent Morgan was able to report it, correct.
Now, after this crime happened, there was diagnoses that you rendered with respect to Ms. Geiser, that now things are different 10 years later. Is that a correct statement of things?
Certainly, she's now received different diagnoses than she did during the history or pendency of this case and in the years after.
And I think you were asked this by Mr. Sapakowicz, but with respect to a child at the age of 12 years old, you yourself as an experienced doctor, you're trying to assess the mental functioning of a 12-year-old. That was sort of your task back then, right?
Correct.
And as part, I don't want to put words in your mouth, but as part of that task, you're looking at the professional literature, the DSM, and things like that, right?
Correct. There was a wealth of records, the collateral interviews with her parents, meeting with her, psychological testing.
Right. And I guess I just want to drill down into this because I'm not clear on, when we have diagnoses like schizophrenia, bipolar disorder, the diagnoses we see in the DSM, is this validated with respect to 12-year-olds or 11-year-olds?
Well, for example, bipolar disorder isn't a condition that we would place on a 12-year-old.
Let's just use the schizophrenia because that was a diagnosis. Is the DSM validated that this has been assessed on 12-year-olds?
The DSM does contain diagnoses that can be applied to individuals across the lifespan.
Okay. But isn't there a particular problem with children assessing what might be a vivid imagination, a child as they're 11, 12 years old versus auditory and visual hallucinations? Isn't it difficult to really diagnose and assess what's going on in the head?
Yes, it's difficult to conduct mental health evaluations with adolescents or 12-year-olds or children because you're trying to identify and define a moving target.
Right, the child's brain is developing.
Yes.
And a 10-year-old, maybe the 9-year-old.
Excuse me, I'm just going to interrupt you. I've got this tickle in my throat.
I wasn't sure if I should stop or not. I don't want to.
It was good because everybody's missing it. Just going to take about a 5-minute recess.
Okay, great.
And doctor, you can step down.
Luckily it's recording, so I just have to just brief notes for myself, but then when I go back and actually type it, I can start and stop, so then it's easier, but you're doing good, don't worry.
Yeah, I've always picked. It's actually, I think, my sixth go around at jury home. So I enjoy it. It's different. Under 17 is jury home. If you're 17, you're an adult court. More
All rise.
Thank you. Please be seated. We'll be back on the record then. Thank you. You may continue now with your comments.
Thank you, Judge. When we left off, Doctor, I was just trying to understand. I hope my question was somewhat understandable, but back then, 2014, you're dealing with Morgan as a 12-year-old girl, right?
Yes.
With, 12-year-olds have an imagination, they have an undeveloped brain. Would you agree with that?
You'd say they have a developing brain, yes.
Yeah, I shouldn't say undeveloped, developing brain. And doesn't the psychiatric literature recognize that it's difficult to diagnose psychotic spectrum disorder with children because of the vivid imaginations and developing brains that they have?
Among other reasons, yes.
Okay. And that could be part of the problem here then, right? That Morgan had a vivid imagination, a developing brain, but now she's much more mature as a young woman in her early 20s.
Yes.
Now, this is the third report you've done, and it sounds like it's a long report and you've reviewed a lot of records. Do you agree with that?
Yes.
And really what we're trying to figure out here, what you're trying to offer an opinion on is, and you use the phrase when it's granted, eventually you predict that release should be granted. Will Morgan be safe in the community? That's essentially what this comes down to, doesn't it?
Yes, whether she would pose a significant risk.
And, right. And when the court grants that petition, whenever that is, if it's tomorrow, if it's 6 months from now, but when the court grants that petition, does Morgan simply do they just open the doors of Winnebago Mental Hospital and let her walk out into the community?
No.
What do they do?
It's my understanding, in general, that when an individual's petition is granted by the court, then the Department of Health Services, in coordination with their community-based contracted provider, has 60 days to develop a conditional release plan.
Okay, so once the court has issued the green light, let's say, then Morgan goes back to Winnebago. She goes back to the mental hospital, right?
Yes.
And once she's back there, then a plan is developed over the next 60 days and presented to the judge.
Correct.
And you called it a what type of plan?
Conditional release plan.
What does that involve? What does that consist of?
That consists in general in enumerating the conditions under which someone is being released, the rules that they have to abide by or agree to abide by on conditional release, provides for provisions of place of residence, level of supervision, psychiatric treatment, other mental health treatment, other types of treatment that the individual may need.
Okay, and that plan goes back to Judge Boren or the judge who's overseeing the case.
Yes.
And then that plan either gets approved or modified or rejected.
Yes.
Okay. Meanwhile, while that plan is being developed, in any future hearings related to that plan, Morgan still remains in the hospital at Winnebago, right?
Yes.
A place of which she has achieved, of which she has achieved maximum privileges.
Yes.
And would you agree with me, not only has she achieved maximum privileges, but there's nothing else she can do at that facility to have any more opportunity to be released into the community or walk around the grounds or anything like that, right?
I would say there are other ways that she can invest herself in treatment. Yes.
Okay. So they could keep working on other treatment things while she's there, right?
And she could invest herself in those too and
Right.
keep investing herself as she has.
Okay. Now, you've talked about the previous conditional release reports you've done, one in 2022, one in 2023. So I want to walk through a little bit of those, okay?
Yes.
So in 2022, one of the concerns back then, 2 years ago, almost 2 years ago, was that there had been a suicide attempt, and you've talked about that, right?
Yes.
But then, after the suicide attempt, you noted in your report that Morgan's engagement with treatment improved. Would you agree with that?
Yes.
And that she remained compliant with all medication requirements?
Yes.
And that her acting out diminished?
Yes, I may have used language like it wasn't entirely extinguished, but it was certainly diminished, reduced.
And in fact, even back then, in that report, you said Morgan is not ready now, but she will be with continued progress at the facility. Didn't you say that?
Yes, I anticipated that continuing her current trajectory at that time, that her readiness for conditional release would follow.
Your exact words were, assuming she continues her current trajectory. And I want to stop there. Current trajectory meaning no suicide attempts, no acting out, no violent behavior, right?
Yes, an investment in treatment,
Yep,
clients with treatment.
right. The trajectory she was on, assuming she continues that trajectory, actively participating in treatment, her conditional release readiness will follow, right?
Yes,
And as you know, we didn't come to court and seek release at that time. Morgan chose to withdraw her petition. You understand that, right?
yes,
And then fast forward to August of 2023, a year later, you author another report, right?
yes.
What's significant at this time in August of 2023, doctor, is that Morgan is now in the pre-integration unit at Winnebago. Would you agree with that?
Yes.
What is the pre-integration unit?
Of the 4 levels, and by moving through those levels, an individual has the opportunity to gain more and more privileges and liberty, responsibility. So she was at the highest or least restrictive and had the opportunity to have the most privileges at that level.
Morgan, when she's at Winnebago, is assessed on an almost constant basis throughout her time there, isn't she?
Yes,
She's observed by staff, by doctors, by social workers, by her integration team. There's a variety of people who are observing her behavior, right?
yes,
And when you talk about 4 units, what you're referring to is highly restrictive, least restrictive unit, all the way to the one where they give them the most privileges.
I would say in the context of pre-integration phase, I'm talking about levels on her unit where she's remained. So it's levels of liberty.
Okay, so within a pre-integration phase, pre-integration meaning they're trying to get somebody ready to integrate into the community, right?
Yes,
Morgan, almost a year ago, August of 2023, she's at the highest rung of the ladder, so to speak, in terms of privileges she gets.
she's at least at the highest of those 4 rungs. She hadn't yet received the highest level of privilege within the pre-integration phase.
And one thing that was significant that you noted, Dr. Collins, was that at that point, Morgan had underwent or participated in 6 supervised outings from the facility.
Yes.
What are supervised outings?
Supervised outings are when an individual who has this level or this privilege is accompanied by staff and has outings into the community, perhaps to go to a cafe, for example, or a store, and to go shopping, or a restaurant, or a library. So they get experience and exposure in the community.
You noted in your report that Ms. Geiser had outings to a library, cafe, restaurant, thrift store, dollar store. Does that sound right?
Yes.
And you said 6 or 7 supervised outings, right?
Yes, that's what the record, the best information I had from the record and her.
Right, because Morgan also corroborates that.
Yes.
And she can narrate what those experiences were like and recall them, right?
Yes.
And there were no problems whatsoever during those outings, right?
Correct.
So Morgan is leaving the facility, she's going out into the community, she spends time at a cafe, she eats a meal at a restaurant, she goes shopping at some stores, no problems.
Correct.
The reason Winnebago does that is because it's sort of twofold, correct me if I'm wrong, but one is to give the person some release opportunities so they can have some semblance of normalcy, and another would be to be able to assess their behavior in that sort of semi-structured environment.
Yes.
And certainly there's people who act out and the facility realizes right away this is a bad idea, this person can't handle their newfound freedom.
Yes, I have seen that happen, not personally, but through records and evaluations that I've done.
And then there's other people like Ms. Geiser who they're just essentially perfect, there's no problem, and they continue receiving those privileges.
Correct.
Now, a very significant point back then, would you agree, was that Morgan's psychotic medication that she had been prescribed for so many years had actually been discontinued a year prior.
Approximately, I think it was 10 months or so, yes.
So in 2022, maybe the end of 2022, the antipsychotic medication was discontinued entirely.
Yes,
You are a forensic psychologist.
yes,
You have had the opportunity to study the literature and personally assess any number, hundreds if not thousands of people with psychotic symptoms.
yes,
Would you agree with me that people who are genuinely psychotic, psychotic condition, that when those meds are discontinued, you see a recurrence of symptoms and a digression in their behavior?
perhaps not immediately, but if someone has a psychotic spectrum disorder, schizophrenia, for example,
Right.
then those symptoms wax and wane. But yes, one would expect a recurrence of those. Of course, you can't predict when.
Right, but it would be very unusual 2 years later to not have seen a recurrence of some symptoms.
Certainly, it's at least atypical.
Right. Have you ever seen that before, where somebody who is actively psychotic, they remove the medication, and 2 years later they're still doing fine?
I don't recall.
But in any event, it was significant enough that you noted in your report that Morgan was discontinued from the antipsychotic medication, and that was a decision made by the treating doctors at Winnebago.
For treating psychiatrist, yes.
Or her treating, Dr. Pope, her treating psychiatrist at the time.
Yes.
Now, nothing happens in the facility in terms of medication decisions without the input of doctors and medical professionals, because it's a medical institution, right?
A psychiatric institution, yes, as
Right.
compared to a medical hospital.
Provides mental health services.
Yes.
And when the doctors, do you know in this case whether Dr. Pope, through her work with Morgan, simply made that recommendation of, it's my opinion as the doctor, we should discontinue this? Or was it Morgan expressing a desire to discontinue the medication, or do you not know?
I believe it was a collaboration with Morgan.
Okay. And it was done in a way where the medication is discontinued, but the doctors and the professionals will still keep an eye on Morgan or Ms. Geiser to make sure there's no recurrence of any concerning behavior or symptoms, right?
Correct.
If a person genuinely hears voices and they're motivated by auditory hallucinations, the doctors at Winnebago know how to look for that and look for the signs of that, right?
Yes.
They're trained, these are highly trained doctors that deal with these types of cases on a daily basis, right?
Yes.
Most of the people, if not all of the people at Winnebago, have at some point been diagnosed with a serious mental health condition.
The patients, yes.
Thank you for that clarification. And you noted, doctor, that in the wake of the medication changes, Ms. Geiser demonstrated no recurrence in signs of psychotic symptoms. Didn't you observe that or note that?
Yes.
Now, back then, August of 2023, you weren't quite ready to support release. Agreed?
I was not ready. Did not believe the facts supported her release.
One thing you noted is that there were, as you described it, not enough opportunities for Ms. Geiser to demonstrate her ability to safely manage stressors, liberty, and responsibilities, right?
Yes.
Can we distill that down to just essentially saying you wanted to see more time lapse without problems developing?
Yes, among other things I noted in my report.
Well, one thing you did note was that Ms. Geiser is, these are your words, that Ms. Geiser is notably closer to readiness for conditional release than previously.
Yes.
Notably closer.
Yes.
And when you say then previously, are you referring to the report you drafted in 2022?
Yes.
And prior to her release, you wanted to see numerous opportunities for community outings, part-time employment, and you also wanted to see Morgan organizing her time with pro-social activities, right?
Yes.
I want to talk or ask you briefly about Ms. Geiser's current clinical presentation. Obviously here in court she's in shackles, but when you see her at Winnebago, she doesn't look like she looks right now, does she?
No.
How would you describe her appearance to you when you visited with her?
Put together. She wore a coordinated outfit. She was ready for the occasion of the evaluation. I subsequently learned that she had met with 2 examiners on the same day, but she arrived prepared.
Okay.
So she came with her recovery plan, for example, a copy of that. She had obviously prepared to meet with me.
And would you describe her as engaged in your interview?
Yes.
Did Morgan disdain, or did she disclaim psychotic symptoms at that time?
She disclaimed a history of Frank. You mean to me in the moments of the interview?
Yeah.
Yes.
And that's consistent with what the professionals at Winnebago decided when they made a decision to discontinue the psychotropic medication, right?
I would say it's consistent with the observations of Morgan, of Ms. Geiser, that had accrued in and around the time I met with her. So there was a consistency between what was said in the record and how she presented.
Okay. Now, when you're interviewing her in 2024, right? You're interviewing her this year.
February 13th.
So now, since late 2022, as far as you can tell from the records, Ms. Geiser has not had her psychotropic medication going back to the end of 2022, right?
She's not had antipsychotic medication prescribed to her.
She takes medication for her anxiety conditions.
Yes.
So people who start to manifest dangerous symptoms when their psychotropic medication is discontinued, the doctors at Winnebago, they can apply for court orders or seek a medication order or forcibly medicate people, right?
Depending on the circumstances, yes.
And you would agree with me that it's not just that Morgan disclaims the psychotic symptoms, it's that all of the doctors that are treating her must necessarily agree with that because nobody is forcing her to take any antipsychotic medication, right?
I would say I know that they don't perceive her as actively psychotic now because it's not noted in her psychiatry records, for example. She's noted as not exhibiting or endorsing psychotic symptoms.
And in fact, there's a consensus, isn't there a consensus across all the doctors that Morgan is not a diagnosis of a schizophrenic diagnosis, right? That's not the current diagnosis for her.
Correct.
By any doctor.
By her treatment team, her treating diagnoses do not include a psychotic spectrum disorder at this time.
And anti-anxiety medication, the state asked you about anxiety. Anxiety is where a person just has nervousness, right? Isn't that what anxiety is? A person just feels nervous about things?
Well, that's one form that anxiety can take. It can also take others, panic attacks, for example.
Okay, so Morgan takes these medications as required, as prescribed.
Yes.
To help with, what is her anxiety condition? Do you know is it panic attacks or is it just she has stress or what does she suffer from?
As I recall from the recent informational letter to the court, the 2 anxiety conditions she was identified with or that they listed as her treating diagnoses are generalized anxiety disorder and social anxiety disorder. Okay. She has other diagnoses.
Generalized anxiety disorder means what?
Just about what it sounds like from the name. Generalized anxiety as compared to anxiety occurring with a particular trigger in mind or in a particular circumstance, like social anxiety disorder.
Okay, is it possible that the reason she has a generalized anxiety disorder is because she's been committed to a mental institution throughout her adolescence and her early 20s?
I wouldn't attribute the level of anxiety that Ms. Geiser has exhibited merely to her being placed in an institution. Certainly, circumstances in an institution can be very stressful and contribute to anxiety, but I wouldn't blame her psychiatric conditions on the institution that she's placed in.
What would you blame it on?
Probably has multiple sources, if you will, and could be exacerbated by stressful circumstances in the institution.
Like being sexually assaulted by your father as a young child?
That can be a contributing factor, yes.
And then finding yourself in a juvenile detention center at 11 or 12 years old?
Yes.
And then obviously spending one's entire teenage years in the mental hospital when Winnebago would exacerbate it, is what you're saying?
Yes.
Okay. So it would seem that one way to reduce the exacerbation of that, and maybe you note this, and maybe you the thought of this in your report, would be to work towards release from that institution so that she can go into a less anxiety-producing environment. Fair to say?
Well, I would say you're trading one source of anxiety or one type of anxiety-producing environment for another, because conditional release is surely accompanied by multiple sources of anxiety for someone who spent a decade in an institution. So it's 6 in one, half dozen in the other.
Sure, but it has to happen at some point. You recognize in your report, you even say she should get out in the near future, don't you?
I framed it a little bit differently from the perspective of a psychologist. So it's my opinion that she is no longer going to meet criteria, that she's going to meet criteria for release in the coming months.
Right, months, not years.
Assuming she continues the direction that she's going and her investment in treatment and any other caveats that I offer in my report, yes.
One thing that was significant that gave you confidence in Morgan's ability to be released is the fact that she has the RAP plan and really has seemed to put a lot of thought into that. Would you agree?
I would say that was one among several factors.
I'll go through some of the others, but the RAP plan itself was very significant because it demonstrates that Morgan herself has really thought hard about what her experiences might look like outside of an institution.
Yes, she's future-oriented, and she's goal-oriented as well.
And goal-oriented in a reasonable way, would you agree?
In the main, yes.
Give or take, depending on the career field. But what I'm saying is, Morgan doesn't come to you and say, my first plan upon release is I want to go run for office and become a president. She doesn't offer some completely detached from reality game plan, right?
Correct.
She says things like, I want to be an author.
Yes.
I want to be a custodian, a janitor.
That part-time work for her might entail that, and that she believed she could do that it would be in a circumstance that wouldn't be too stressful, for example.
Right, that's a really good sign that she has thought, well, I might be in a quiet building, it might be after hours, I might have headphones in and I can clean floors and do janitorial work, right?
Yes.
The CNA thing is maybe a little bit more complicated because it might require a financial investment in enrolling in school, but it's not delusional for her to think, well, maybe I could be a CNA and help other people.
It's not delusional, no.
Well, it's far better than delusional. It's a fairly concrete plan for somebody in this position to have, isn't it?
Yes, it's a concrete plan.
And it's also a realistic plan, something she could do or aspire to do.
Something she could aspire to do.
I suppose whether the facility would hire her becomes what you're probably thinking, the whole other question.
Yes.
Right. But in any event, she doesn't say, I'm going to become a doctor within the first 6 years of getting out of here, right?
Correct.
And Morgan, to her credit, you noted she has 99% group attendance rate.
Yes.
Not a single security hold since August of 2019.
Yes.
And full courtyard liberty, did I note that correctly?
Yes.
And full escorted liberty.
Recently granted, yes.
Did you review, at the beginning of this hearing, I think you were in here, the judge mentioned a February 8th, 2024 risk assessment. Did you review that?
Yes.
Do you remember the contents of it, or do you have it in front of you?
I don't have the document in front of me. There is a summary in my report of it.
Right. And that report is prepared, having done these before, what's the purpose of that report?
The purpose, as I recall, of that report was to appraise whether or not Morgan was appropriate, Ms. Geiser was appropriate to continue at the current privilege level that she had, and it was occurring approximate to her being considered for full escorted liberty in the institution. So whether or not she was safe to do that, if you will, in the institution.
And this report doesn't make a pitch, so to speak, of release or not release, right?
Correct.
It's generally just an overall overarching picture of Ms. Geiser, her diagnoses, and her progress, right?
It's a violence risk assessment.
Now, that report, do you agree with the conclusions of that report that the first diagnosis, or that her diagnoses, are post-traumatic stress disorder, and then the anxiety disorders you mentioned, and then some borderline personality traits?
Yes.
Generally, as a doctor in this field, a psychologist, should we look at this as like order of importance, that probably it's PTSD first with some lesser anxiety condition with some lesser personality trait issues?
That depends on the intent of the individual who listed them.
Okay.
There is history in the field of listing the most sort of the controlling or overarching diagnosis first, but that's not necessarily, doesn't translate into day-to-day notes or a report like this.
Would you yourself agree with that order of prioritizing it in that fashion, that the most pronounced issue, if you will, that Ms. Geiser is dealing with would really be PTSD? Would you agree with that?
Currently, yes.
And PTSD is post-traumatic stress disorder.
Yes.
We sometimes think of that from people who have been through traumatic experiences.
I would say we always think about people who've been in traumatic experiences.
So that's what causes it, is the traumatic experiences. That, in other words, PTSD is created, so to speak. A person gets it because they go through traumatic experiences. They're not born with PTSD.
Correct.
Versus other conditions like schizophrenia or perhaps bipolar disorder, a person might just be born with that, right?
Or be vulnerable or predisposed to develop that condition.
Because of some hereditary factors.
Among other factors, yes.
So post-traumatic stress disorder for Morgan, if we're talking about her as an individual, some of that would come from those childhood traumatic experiences that we just discussed earlier, right?
Yes.
But also just growing up in an institutional setting and witnessing people who are actively psychotic and perhaps more dangerous than you, that can create a PTSD condition as well, right?
I would say that can contribute to it and certainly not help the index offense itself also.
Yeah, even the crime, even the juvenile criminal event that happened.
Yes.
Now, as the treating doctors can't fix, obviously things happen to people and they have their experiences and that can't be rectified, but doctors know how to treat PTSD, right? That's a fairly common condition.
Yes, there are treatment protocols and methods for treating PTSD.
Are the medications that Morgan, you talked in your report a little bit about Morgan developing coping skills. Do you remember when you talked about that?
Yes.
Isn't that what somebody like Ms. Geiser is taught, is you handle your PTSD by recognizing the condition first and then developing coping skills to handle it?
That's one approach. That's not, strictly speaking, the only approach to treating PTSD, but certainly assisting someone in developing coping mechanisms, but also in addressing the symptoms themselves.
And have the symptoms been addressed with Ms. Geiser?
I would say they're in process of being addressed.
Now, that report that we were just talking about, the February 8th report, describes Ms. Geiser as, quote, psychiatrically stable. Would you agree with that?
Yes.
And that she's been that way for quite some time?
Yes.
And that this report describes her as a low risk for violence?
Yes.
And that's based on her behavior?
Based on everything that went into that evaluation, and her behavior is a part of that.
One thing that was significant was that, well, you would agree, at Winnebago, for example, there's many people who are much worse, if you will, than Ms. Geiser, people with actively psychotic symptoms who are acting out and acting in a self-injurious or dangerous manner, right?
Yes.
And obviously Ms. Geiser's been exposed to that in whatever way she's been exposed to it just by nature of being there, right?
Yes.
Now, in January of 2024, there was conflict that Ms. Geiser had with a peer, and your report said that she vented and she was able to work through the conflict. That was something you thought was significant.
Yes.
Why?
Because that goes in the column of an individual's ability to have nonviolent conflict and to control themselves in the face of conflict.
When I look at, and I'm looking, do you have your report in front of you, I assume, right, doctor?
I do.
So I think judge has given you permission to refresh if you need to, but I'm looking specifically at page 29 of your report where you describe Ms. Geiser as calm and respectful. Would you agree?
If you can direct me on page 29 to the paragraph you're referring.
So the middle of the page on page 29, it says by 2/6/24. Do you see that paragraph?
Yes.
In that paragraph, you describe her as psychiatrically stable.
Correct. What I'm doing is describing how Ms. Geiser is characterized by records accrued on that date.
Okay, this is your review of the records that the doctors are creating, right?
Yes.
And let's talk specifically then about the ultimate conclusions. I know the state talked about it, but correct me if I'm wrong, but what you're saying to Judge Boren is you're attempting to look at the statute and what the factors are for the court to consider and make a determination about whether her release today would present a risk of bodily harm or danger to herself or others or property, right?
Yes.
And do you agree with me? That's sort of what the statute talks about, is it almost refers to how do things look today in this moment in April of 2024, right?
Yes. What do I know now as I'm doing the evaluation?
Okay. And because you've had a long opportunity to work with Ms. Geiser, it seems to me that what's occurring through your reports is an observation that Ms. Geiser has been making sustained progress over the course of 3 evaluations you've done for conditional release.
Yes, I would say ongoing progress across those evaluations and over time.
And your exact words are, it is this examiner's belief, meaning your belief, Dr. Collins, that Ms. Geiser's readiness for release should follow in the coming months, assuming she maintains her current level of psychiatric stability, continued compliance with and progress in treatment, that she remains free of psychotic symptoms, and that she continues to develop coping skills for managing the anticipated stressors of conditional release, symptoms of anxiety and trauma, right?
Yes.
And you want to see that she continues to actively develop her support system in the interim and improve her stress tolerance, coping skills, and capacity to navigate stressors, right?
Yes.
Because as you note, I think everybody agrees and understands there will be stressors when she's released, right?
Yes.
But would you agree, that's the whole point of a conditional release committee creating, you talked earlier about a 60-day plan that's created. Isn't that the point of that plan?
I'm not sure I understand the question.
That once a court approves somebody for conditional release, there's a whole planning process that goes into it. Didn't you testify to that before?
Yes.
So the team gets together, and Morgan, this is a team that Morgan already has a relationship with, right?
At least a couple of members of that team, yes.
Your report talks about Ms. Geiser having weekly or maybe it's monthly contact with one or more members of her release planning team, right?
Yes.
So there's a team that's already been put together that is ready for when the judge approves it, whenever that is, but when the judge gives the green light, that team is ready to work with Morgan to develop the plan to send her into the community, right?
Yes, I believe pieces of that team are in place. I don't know that the whole team has been assembled, for example, because it's still theoretical.
Right, because it hasn't been granted yet.
Correct.
But if it is, if it's granted, and if over the next coming months, call it 2 months, you don't say a number of months in your report, let's call it 2 months, 3 months, 4 months, over that period of time, if Morgan continues on the track she's on and continues doing the things that you describe here, then you would say it's appropriate for her to be in the community, right?
There will be a point when I anticipate she will be or believe she will be ready for conditional release in the coming months.
Okay. How many months is that, if you had to estimate? Is it 2?
I don't know.
Let's just assume hypothetically the path that you've seen with Morgan, the positive trajectory you've seen, let's just assume it continues exactly as you've seen. Is 2 more months at Winnebago sufficient?
My best estimate would be 6 to 12 months.
Okay. So you'd like to see some perhaps 6 to 12 month period of time where Morgan is continuing to make this progress, address the things you've mentioned here, and then at that point you would say, okay, there's going to be a plan put in place, she'll be safe in the community. It would be your prediction.
I don't make predictions. I don't know the future. But it's my belief that assuming the things I've delineated in my report, that she will be ready for conditional release in the coming approximately 6 to 12 months.
Thank you. That's all I have.
All right, thank you. Redirect, Attorney Zepekowicz.
And not until that 6 to 12 month period of time would she not represent a significant risk, correct?
It's my opinion, to a reasonable degree of professional certainty, that she currently presents a significant risk of bodily harm to herself or others if conditionally released. When pressed to estimate number of months, I would estimate 6 to 12 months. I know she's not ready now.
Nothing else, Judge.
Any further cross?
No.
Doctor, I have a couple questions. What, based upon your review of records and Ms. Geiser, what is her intellectual ability?
We know she has historically a measured full-scale IQ of roughly 129 in the superior range. There have been some other scores that are slightly lower, but well above average, high average to superior range. She's a bright young woman.
With her historical reporting that she faked a number of assertions that the things she faked had an impact on the diagnoses that she carried. Is that true?
If, in fact, she faked those symptoms.
Well, yeah, right. We're assuming that when she reported faking, that was a true report. But whether they were true or false, her statements that she says were faked had an impact on the diagnoses that she carried up to that time.
Yes.
Is she capable of manipulating and manufacturing circumstances to place herself in a position that's most favorable from her view?
She has that capacity, or that intellectual capacity. But what mitigates that in this circumstance is that she's observed 24 hours a day. So you can't, for example, it's questionable that she would have been able to malinger and pull the wool over the eyes of so many mental health professionals. What's more likely is what she hinted at during the interview with me, in that at the time she was going through this, she may well have been dissociating because of the trauma she was experiencing, and the best labels we could put on it were psychotic symptoms. We know she wasn't well, and the records are replete for years that she wasn't well. And it's incredible to think that she could have faked that well, something she didn't know how to do. She appeared psychotic before she ever arrived to the doorstep of a mental health institution.
On the revelation that she made that she was faking, is there any indication as to why she would now report faking if it wasn't true?
I don't know the answer to that, Judge.
You know, I keep thinking of that statement by Abraham Lincoln. You can fool all of the people some of the time, some of the people all of the time, but not all of the people all of the time. Is this a situation that we're in?
I don't think so.
Well, I have a question regarding your report on page 33. In that middle paragraph that begins, I recognize, and that's where that quote is in parentheses. How do you think I was able to repeatedly stab my best friend and bitch-faced co-defendant thought she was all the brains? I was pulling her along too. I didn't care. I can't care. I never known how to care. 3 dots, end quote, etc. I guess I'm trying to place that statement in context. How did that develop that she made that revelation or statement to the people she was talking to?
It wasn't people, it was her therapist. So It was in the context of therapy. And that's how it has to be understood. For more context about that, we could go back in my report where I talk about the record review. And I'm on page 27, the second full paragraph.
Let me just get there. I'm there. All right. That's the paragraph that begins in a session?
Yep, on 10/24/23.
All right.
So that's some information about the context of what she and her therapist were talking about and Ms. Geiser's reaction to it. She got upset with her therapist, and that's when this blow-up happened, or blurting out happened. Again, I have to put the caveat that in the context of therapy, one is supposed to talk about difficult things, and things can get emotion charged. So for my purposes, or from my perspective, it was a potential red flag, and I couldn't look away from that when I came down on my opinion that she wasn't ready at this time for conditional release.
All right. Thank you. Now, Attorney Zapakowicz, any questions based upon my questions?
No.
Attorney Cotton, any questions?
Yes. I just want to put a fine point on that. You're saying for your purposes, meaning the role you inhabit right now, making a recommendation for conditional release, right?
Yes.
But if we put on another hat, which you were just alluding to, of the therapist hat, that's a good thing, that statement.
It can be a good thing, yes.
It can be a good thing because the point of individual therapy is to people, you said before, people who have been through it understand that what the point of individual therapy is to get people out of their shell, to make those types of raw emotional statements at times, right?
To get to what really matters.
Right.
Yes.
And sometimes you've got to break the shell, and it can become, as you said, emotionally heated and charged.
Yes.
So this is one remark in the context of many years of individual therapy, almost a breakthrough moment with a therapist. Fair?
I don't know whether it was a breakthrough moment with the therapist. It could have been. I don't know.
But of all the records you look at, and thousands of pages of medical records, that's the only concerning statement you've been able to identify in all her years of treatment that you pointed out in your report, right?
At least of those records that accrued in the interim between the 2023 evaluation and present.
Okay.
That stood out.
Okay, thank you. That's all.
Any questions based?
Good or bad feelings relative to anyone or anything, and then talks about how I didn't care, I've never known how to care. That presents as someone who represents a danger to other people, doesn't it?
Taken in isolation, perhaps, but if you look at follow-up therapy notes from in the paragraph to follow, it appears what Ms. Geiser was saying was her conclusion that she must not have been able to care, because who could care who did this to their best friend, as compared to that she was really claiming to not care.
But that doesn't really explain the comments about being dead inside or having no good or bad feelings relative to anyone or anything. So it would be fair to say that it's hard to know how to take that, correct?
In isolation, yes, it's hard to know. We do know that Ms. Geiser has the capacity to form attachments, can express joy when she has a good visit with a couple of family members that come. So I would say that from the broader perspective, it's unlikely that that reflects a callous, fundamental personality structure, for example, for Ms. Geiser. That's just contradicted by other information in the record.
Nothing else.
Nothing.
I have another question. You talked about her level of freedom, if you will, at the institution and how she circulates and gets about. So that she's not at the top level. What is the next level that she could be at?
I believe she was granted the highest level available just earlier this year. So now she is permitted, when she can use it, through no fault of her own, to share full escorted privileges. You have to share it with the patient. You have to engage in that on grounds with another patient who holds that level. At this time, or at least when I met with her, for Ms. Geiser's purposes, in order to use that, she would have to access someone else who's on another unit with a different schedule, for example. So her opportunities so far to exercise that, to be able at designated times to walk with the other patient without any staff to canteen, for example, has just been limited, partly because she's only been recently granted it, and partly because the patient who shares that level, you have to only share, the rule is, the other patient has to have that same level, is on another unit.
She's been able to access off-institution grounds.
Escorted.
Escorted.
Supervised.
Supervised. Does she ever, is a level of supervision available where she can go about off-institution grounds unescorted?
I don't believe so. I don't believe that level of privilege exists.
All right, thank you. Any further questions, Attorney Zepekowicz?
No.
Attorney Cotton?
No.
All right. Are you moving into admission in Exhibit 1 and 2?
I would so move, Judge.
Any objections?
No.
Okay, 1 and 2 are received, so ordered. Thank you for being here.
Thank you, Your
Have a
Honor.
good day.
You as well.
Is Dr. Collins under subpoena?
No, I think it was simply notified by the court, and I have no problem with her being excused.
All right. Attorney Cotton, any issues?
No.
All right, thank you. Do you want to take a brief recess and we call another witness? Or do you want to go ahead?
Sure, we're prepared to continue.
Okay, who is the next witness?
State calls Dr. Lundbaum.
Oh, we just have a 2-minute break on our end, I'm sorry.
Sure, that's fine. Let's take 5 minutes. 2 minutes is hard to function in.
Judge, do you want me to come up right away, or should I wait?
No, you can wait. Unless you have a book to read.
Well, you know.
No, you could stay down there. That's fine.
I've got lots of things to read always, so.
All right.
Yes.
No, no.
All rise.
Okay, thank you. Please be seated. We're ready to proceed. Then Attorney Nicolae, you were going to call another witness.
Thank you, Judge. State calls Dr. Lundbaum.
Doctor, if you'd come forward. Then raise your right hand. Clerk will swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, thank you. Then be seated. Microphone is the bar with the red light. Just speak directly into that. Would you state your full name and spell your last name?
My name is Dr. Brooke Lundbaum. First name is spelled B-R-O-O-K-E. Last name is L-U-N-D-B-O-H-M.
M or N?
M, as in Mary.
All right, very good. Thank you. All right, Attorney Nicolae.
Thank you, Judge. Dr. Lundbaum, I'm going to hand you what's been marked as State's Exhibits 3 and 4. And first, looking at Exhibit 3, Doctor, do you recognize what that is?
Yes, it is a copy of my CV.
Is that a multiple-page exhibit?
It is. It is currently about 6 pages.
Does that look like a fair and accurate copy of the recent version of your professional resume?
Yes.
I move Exhibit 3 into evidence.
Any objections?
No objection.
Okay, received.
Doctor, could you please explain the degrees that you hold for the court and the schooling that you've had?
So I received a bachelor degree from Hamilton College in 2002 with a concentration in psychology, minoring in sociology. I then went on to do a master's in clinical psychology through the Minnesota School of Professional Psychology, received that in 2006. Through that same school then, I went on to finish up the doctorate in clinical psychology, graduating there in 2008.
And what is your current employment?
I have a couple different roles. So I have a private practice through behavioral consultants. With my private practice, I do a variety of different kinds of psychological evaluations within the court system, both civil and criminal courts, juvenile courts. I also am the clinical director for what we call the Outpatient Competency Restoration Program, or OCRP. That is a statewide program that is sponsored through the Department of Human Services, relating to the remediation of adult defendants who have been found not competent to proceed, but who are able to remain within the community. I am the Vice President of Behavioral Consultants.
And in that capacity, do you work with Dr. Collins, who just testified?
I do.
Okay. And in order to perform your duties for all of your areas of employment, have you maintained your license as a psychologist in this state?
Yes.
In terms of the evaluations that you're conducting for your private practice, what types of court evaluations are you performing in the criminal context?
So within my private practice, I do an array of things. So conditional release, which is how I became involved in this particular case currently. I have done mental responsibility evaluations, competency examinations for juveniles, evaluations relative to waiver or reverse waiver, regarding whether or not a person should stay in juvenile court versus adult court. I have done guardianship evaluations, some civil commitment. There's just an array of different things. I should also mention that I do have some contract work that I do with the Wisconsin Forensic Unit, which is competency examinations for adult defendants.
Okay. How long have you been performing those types of evaluations?
I started with the Wisconsin Forensic Unit and behavioral consultants during my pre-internship, or my internship year, or actually, no, I'm sorry, postdoctoral fellowship year. So 2008 to 2009. I was then licensed in 2009, and I've continued to work with those agencies since then in a variety of different capacities.
Specifically, in terms of evaluations for appropriateness for conditional release, have you performed many of those evaluations throughout your career?
I have.
And were you asked to perform one of those types of evaluations, in this case involving Morgan Geyser?
I was.
Could you just remind the court how you became involved in Ms. Geyser's case?
So I have been involved in Ms. Geyser's case for now going on 10 years. I initially became involved by doing a court-ordered competency examination within weeks of her arrest for the index offense. I then came back involved later on doing a mental responsibility evaluation relative to her plea of NGI, or not guilty due to mental disease or defect. I also did a evaluation relative to conditional release versus institutional care. That was soon after her adjudication of the NGI plea. I then have also done now 3 additional conditional release evaluations, one of those with a report not being written due to her decision to withdraw her conditional release petition prior to that being submitted.
For all of those evaluations, did you have an interview with Ms. Geyser?
Yes.
Including this evaluation that we're here for today?
Yes.
Have you ever come to the conclusion that Ms. Geyser is appropriate for conditional release currently?
I have not.
Okay. In terms of other things that you were able to review before forming your opinion today, did you have access to records from Winnebago Mental Health Institute?
Yes.
Did you also consider the underlying index offense?
I did.
Did you consider the violent nature of it?
That isn't part of one factor that I considered amongst a variety of others.
Okay. Ultimately today, do you have an opinion for Judge Boren in terms of whether Ms. Geiser is appropriate for conditional release?
It is my opinion that she continues to pose a significant risk of bodily harm to self, others, or property. So in other words, I'm not in support of her petition for conditional release at this point.
Okay. Throughout your time conducting these evaluations with Ms. Geiser, did you become aware that her self-reported psychiatric symptoms, the nature of the self-report has changed drastically recently?
Within the last couple of years, yes.
Does that fact make your job harder in determining appropriateness for conditional release?
It certainly changes things. There was a rather remarkable shift in the conceptualization of her particular mental health diagnoses, as well as the manner with which she describes herself, the index offense, her history of mental health symptoms. So there's contradiction in that information, which certainly causes some complexities, I'd say.
In terms of a timeline, would it be fair to say that that shift occurred in November of 2022?
So it appears that it was about summer to fall of 2022. In my interview with her for a conditional release petition in June or July of 2022, there was some beginnings of that shift, although it's not quite like her report in the last 2 times that I've met with her. By fall, so for sure November or so, there's clear indication in the record of the shift in how she's been self-reporting her mental health issues.
Could you summarize that shift on a timeline for the court?
So since the index offense, so there has been ample information, observations by various mental health professionals, people who have been involved in her care, across settings, across time, that consistently portray her as an individual with flagrant psychotic spectrum symptoms. Things like delusional ideas, auditory and visual hallucinations, tactile hallucinations or related to touch. There have been indications of thought disorganization, bizarre behavior, bizarre comments, and this would be consistent, again, across reporters, across time, across settings, that these different observations have taken place. The conceptualization with that has been a schizophrenia spectrum disorder. Beginning in 2012, she began to say that she feigned psychotic spectrum symptoms. There were also, prior to that time, her report of significant
I don't remember.
Do you remember the police had to take your hat and glasses off to make sure that it was you in the picture?
Nope, I was focused on one thing only. Somebody with a bat that I've seen in the woods and across that whatever bridge, the little bridge, Rainbow Bridge, whatever. I was focused on him. I was very afraid of that person.
Did you ever say to an officer, hey, there's a guy over there with a bat and that's concerning me, can you do something about it?
No.
You were put into a squad car, right?
Mm-hmm.
Said yes?
Yes.
Sheriff Knudsen came over to make sure you were comfortable, right?
I saw that in the video, yes.
You don't remember talking to Sheriff Knudsen?
No.
You remember him asking you, well, if you don't remember, you don't remember. We're going to play that video and then I have some questions for you. Your Honor, this is the longer version of the video that's been referenced. It's 1 minute and 59 seconds.
House, when you're ready.
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature?
on?
Temperature's okay in here?
Yeah.
Okay.
I hear somebody got stabbed. And I fit the description.
Yes, you do.
All right.
Yep, so we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay.
All right. So I don't know. Okay, well.
Did you see anybody injured?
No.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain, do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names, but, you know, that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Oh, I drove from Prior Lake.
From Prior Lake.
Yeah.
Okay.
Actually, we didn't drive with them. We came here alone.
Your wife and you?
Yeah.
And you met the group here?
Yeah, but we know each other.
Okay. All right. As long as the temperature's good, I'll check back with you in a minute, okay?
Thank you.
Thank you.
You lied to Sheriff Knudsen, right?
I don't remember that conversation. But yes.
In fact, you told him that you heard there was a stabbing, right?
I don't remember any of this stuff.
You're fishing for information about what happened, right?
I don't know what you could say I was fishing. I don't know.
You asked him some questions about what had happened, right?
Again, I don't remember this conversation.
But you were pretending that you didn't know what happened. Isn't that true?
No.
At the point that you were talking to Sheriff Knudsen and saying these things, you didn't know there was a video of what happened on the river, did you?
I didn't know whether I was dead or alive at that point.
But you also didn't know that there was a video, right?
No.
When the sheriff asked you what had happened, one of your responses was it was kids being kids, right?
I don't remember any of that conversation.
You just heard yourself say it on the video, though.
So,
Objection, no foundation.
I'll move on. Prior to being taken to jail, you were transferred from that squad car that you were in to a different squad car, right? Remember that? You remember at some point Deputy Thomason telling you that you were under arrest for homicide and attempted homicide?
I don't remember any of that.
When you spoke with Lieutenant Hart, even though you'd been informed that you were being arrested for homicide, you pretended to know that, to not be aware that someone had died, right? Right? When you were talking to Lieutenant Hart, you...
Over here at the jail?
Yeah.
I don't remember any of that conversation.
You don't recall pretending to not be aware that someone had died?
Objection assumes a fact.
Sustained.
When you're talking to Lieutenant Hart, that was about 4 hours after you'd been arrested, right?
Yeah, that's what I learned.
And said you had time to put together a story, right?
No.
Overruled.
You had 4 hours to come up with a story about what happened on the river. before you were interviewed by Lieutenant Hart, right?
No,
You didn't have that time.
I didn't put a story together.
Okay. So when you told her things like, 2 of these boys pulled knives on me, you're telling the truth?
No.
That was a story, right?
Correct.
And when you said that you somehow managed to grab one of the boys' arms and bend their wrist back and stab them with their own knife, that's a story you made up, right?
I told her what I remembered.
You remember doing that?
No, everything I told her is what I remembered at that time.
At the time you told her these things, you thought that you would grab someone's arm and stab them with their own knife?
As you can see, I was very confused.
Did you not testify earlier that you lied about the knife?
That I did.
And that nobody else had a knife on the river except for you?
That I lied about the knife.
So it's impossible then for you to have twisted someone's arm and stabbed them with their own knife, right?
I saw the video.
No, I'm asking what you said to Lieutenant Hart.
I don't remember the interview, but I saw the video. And
You're aware.
and I know that it's not right. It's not true.
Not just a couple of little lies, but lie on top of lie to Lieutenant Hart, right?
Argumentative.
Sustained.
Well, let's talk about some of the things you told her. You said, these boys took the goggles off my head and threw them down the river, right? You told her that?
If that's what the video recorded, yes.
All right, you told her that these boys tried to pull down your shorts, right?
That's what I saw in the video, but I don't remember the interview.
That's a detail you added for your benefit, right?
No.
You said these boys attacked you, right? You told her that multiple times, right?
I saw the video.
Did you say that or not? Yes or
I
no?
said that in the video. Yes.
And you knew that wasn't true, right?
So, in the video, I lied. I totally lied about the knife. I didn't remember a lot of details. I didn't remember of anything. I don't even remember the interview. I just looking at the video. I can look at it like anybody would look at it for the first time. I don't remember any of that.
You told Lieutenant Hart that these boys told you, "Don't run away from us." You remember saying that?
No foundation.
No.
In fact, it's just the opposite. They were telling you to go, right?
I don't remember.
You told her that a second boy had a knife, attacked you with the knife, and you took that from him, right?
That's what I saw in the video.
That's not true either, right? Right?
That's not true.
You said that when you walked back to your group, and this is talking to Lieutenant Hart, that Ernesto asked you if you had found the phone, right? You remember saying that to her?
I don't remember any of that conversation I had with her.
Yeah, that wasn't true either, right?
If this is all part of that interview, I don't remember anything, so.
That's what we're talking about. We're talking
Right.
about the interview with Lieutenant Hart.
Then I don't remember the interview.
Okay, I still get to ask you questions about
Sure.
it. You were specifically asked, did you have a knife? Right? Do you remember being asked that?
I don't remember that, but I know I was.
Your answer to Lieutenant Hart was no, no, absolutely no, right?
Right. Which I lied, I know I lied about the knife.
You said to her, why did they want to scare me with a knife? Right? Talking about the boys, I mean, the 17-year-olds. When none of them ever had a knife, right? Is that right?
Apparently not.
You said I grabbed it, meaning the knife, from him because he tried to poke me with it. Do you remember saying that?
Nope.
You said a woman hit you in the ear. Do you remember saying that?
Nope.
You know that's not true, right?
Objection, foundation.
Overruled.
You know that's not true as you sit here now, right?
Right.
You told the police and Lieutenant Hart, I think, that you thought it was two different groups of people fighting against each other, right?
I don't remember telling her that.
Right. You know, as you sit here today, that that's completely made up, right?
Again, I don't remember any of that you're talking about right now, if it's about the interview.
You told Lieutenant Hart that you wanted to stay in the area and, you know, watch the police come and arrest these people for fighting, right? That's what you told Lieutenant Hart?
That's what's in the transcript, yes.
When you were told that a person had died, your response was, is it because they fought each other? That's what you told her, right? That's how you responded?
If it's in the transcript. But I don't remember.
You never told Lieutenant Hart that you punched or pushed or did anything to Maddie Cohen, right? You left that part out?
Is that what it's in there?
I'm asking if you ever told her that.
I don't remember.
You didn't mention that you had stabbed and severely injured another woman, Riley Madison. You didn't mention that to Lieutenant Hart, right?
Objection, form.
Overruled.
You never mentioned that part.
I don't remember.
You didn't mention being strangled at any point, right?
If that's the transcript, then that we go by that, but I don't remember that interview.
And I think what you said earlier is that you were afraid you were going to die from being strangled, and that's why you stabbed Isaac Schumann in the heart, right? That was your testimony earlier? Didn't you say that today, this afternoon, here in court?
Yes.
That's not anything you mentioned to any police officer, right?
If I didn't mention, I didn't mention it. I don't remember that.
That's not an important detail that you thought you might want to point out?
Objection, argumentative.
Overruled.
Everything is every detail is important. We all know that. But I don't remember saying any of those things to Lieutenant Hart.
Because you didn't say them, right? That's why you don't remember.
Is what?
You didn't say those things to her. That's why you don't remember, correct?
I don't remember what I said or what I didn't say to her. I don't remember even having an interview with her.
So you can't remember anything about what you told her, but when Mr. Nelson's asking you questions, you can remember all these feelings you had at the time. Is that true?
Overruled.
Do you remember answering his questions about how you were feeling that day?
The feelings I had when I was attacked?
And when you were meeting with the Lieutenant Hart?
Objection, that's. Can we approach?
Yes. Objection sustained. Please rephrase the question.
You testified today a lot about remembering what you were feeling that day, right? When Mr. Nelson was questioning you, right?
Mm-hmm.
Is that a yes?
Yes.
But when you're asked other details that might not be so useful, you don't remember them, right?
Certain feelings and certain, they stick to you forever.
Ones
They
that are
affect you.
helpful to your defense, those stick to you, right? Sustained. You were examined by the jail nurse, the SART nurse, several hours after the incident, right?
Yes.
You never mentioned to her that you'd been strangled, right?
Didn't mention to her a lot, not because I intentionally didn't want to do it. I didn't remember. I was still in shock.
You didn't mention anything about your throat hurting.
I don't remember what I mentioned to her.
I understand. You never, at any point, told anybody, other than today, that you had a sore throat or your throat was sore from after this incident, right?
You didn't tell anybody?
At any point during the day after you were arrested, when you're interviewed with people, when the jail or the SART nurse is talking to you, you never once said, oh, my throat is sore because Isaac Schumann strangled me, right?
I don't remember what I told those guys either. I was, like I said, I don't remember lots of the interaction I had with anybody here at the jail.
But today, almost 2 years later, you remember that the next day your throat hurt.
Yes, because I, yeah. And my back.
You can remember that detail, but not the other details?
Yeah, my back still hurts right now.
The SART nurse specifically asked you, when she was doing the exam, where are you hurt? And you pointed out some things to her, right?
I may have.
Yeah, but you never once said, I had been strangled, I have an injury to my throat hurts, nothing like that.
Objection, asked and answered.
Overruled.
I don't remember.
When she asked you what hurt, you said your butt hurt from the rocks. That was your response to the nurse, right?
Don't remember.
You had said that you're in poor health, or you were at least in poor health back on July 30th of 2022. You had had your bypass surgery 2 years prior to that, right?
Mm-hmm.
Is that a yes?
Yes.
And typically people that have medical procedures like that are given restrictions on what they can do in their activities, right?
Yeah.
And you apparently weren't restricted from swimming, snorkeling, doing outdoor sports on a river, right?
I was for a while, but 2 years later, lots of the restrictions, I believe, got lifted.
Those restrictions got lifted because you got better, right?
You can say the doctor makes that decision, but he says if you feel a little better, do as much as you can.
Yeah, and you were in fact snorkeling and swimming and doing things that day, physical activities, right?
Snorkeling in 15 inches of water, I was mostly I didn't even snorkel. That was not a lake but I was my whole plan for the day was to just float down the river and relax.
You're able to run, at least you were back on July 30th of 2022, right?
Run?
You were able to run at that time, right? You weren't restricted from running.
I mean,
you didn't have a medical restriction to keep you from running, right?
No.
And in fact, you did run when you ran up on Isaac Schumann's group, correct?
You call that run? Okay. That's not a run, but I wasn't running. I wasn't allowed to run or do any activities like that, so I wasn't running.
At the time that this all happened, July 30th, 2022, you felt sufficiently healthy to go off on your own, away from your wife and your group, to go do snorkeling on your own, right?
It's what I felt.
Your Honor, I just want to check my notes. I think I'm almost done. We can have Exhibit 4, Item 10. I'm going to ask Investigator Schultz to actually handle it since it's evidence, physical evidence.
Can you retrieve the exhibit? Oh, it is out.
If investigator can approach the witness, Your Honor.
Yes.
We're showing you what's been marked as Exhibit 4, I guess item 10. That's your knife, right?
Yes,
That's the knife you used to stab these people.
that's the knife I used to defend myself with. Yes.
I asked you earlier about when you stabbed Dante Carlson. You agreed that he was not attacking you at the point that you stabbed him. He was the last person stabbed, right?
He attacked me.
Earlier, but when you stabbed him, Tony Carlson had already broke up the fight, right? You said you agreed to that earlier.
At that time, everybody that came in contact with me attacked me.
Anybody who looked at you?
No, anybody that came in contact with me, I felt attacked.
You felt attacked whether you were being physically attacked or not, right?
I was in the moment, so I felt attacked by anybody that had either previously attacked me or was approaching to attack me.
So you felt like you could stab folks who were not attacking you at the moment that you stabbed them.
Objection.
Sustained. Sustained.
You walked up to Dante Carlson and stabbed him in the belly, right?
I did not walk up to Dante Carlson and stab him in the belly.
I don't have any other questions, Your Honor.
Mr. Nelson?
Jimmy, if you would ask some questions about your fitness on July 30th, I want to ask you some questions about that, okay? Just maybe we can get it done in one question. Did you feel fit enough to take on 13 teenagers and adults in a fight by yourself without a weapon?
I didn't, no.
You were asked some questions about what happened with each of these people, right? And you were shown some stills.
Mhm.
Were you in court when, do you know how many frames are in per second of these videos?
I learned they're like 24, 25.
So one frame is a 24th of a second, is that right?
Correct.
When you were in that, let me play the video. I'm going to play Exhibit 2.
Are you connected?
I think so. Before I am.
Yeah, start over. I don't have anything on my monitor either.
That's not the screen I'm looking at, Judge, I apologize. My screen looks like that.
Screen is this with the library.
That was my, that's my home screen, but. take another chance here, Judge, sorry. See what it looks like for a second. Okay, that's. I don't know, Judge, maybe I need to take a break. I'm looking at my screen and it shows the video, so I apologize. I'm flummoxed.
This is Exhibit 2,
This is Exhibit 2. I want to play it from the 150 mark where you, for 14 seconds. So.
In the spirit of cooperation, are you able to use your exhibit?
Sure. Apologize, sorry. You started right there. The video, please. We can start the video at 150, just when he's. All right. Before we press play, Mr. Miu, do you see what's on the screen there at 149?
Yes.
Is that?
Hey guys, I want to show you the Watts house is for sale again. Let's take a look on Zillow. I interrupt this verdict watch for this news break brought to you by Zillow. We have 2825 Saratoga Trail back up on the market at a whopping $775,000. So let this sink in a little bit. Chris and Shanann bought their house for $399,000 back in whatever year that was, 2013 or something like that. Now their home is worth double that. Had Chris not done what he did, Chris and Shanann Watts, if they were still married, they would have doubled their property value. They would have doubled their property value. And they wouldn't have been in the hole, right? If they didn't take out the I'm having a brain fart. The equity. Can you imagine? Okay, so let's take a look here. $775,000. It last sold in 2022 to the Miller family. Now, I'm about to show you what the Miller family did inside. So not only does the outside look brighter and different, it's not brown anymore. But let's take a look at all of the photos here. Front porch. It looks like they changed the hardware on the door, but you're going to notice when we see the inside of the house, they still have the latch for little CC not being able to get out is still there. So we have the porch. Now we have the inside. And the person who owns this house seems to really like sayings on the wall. So, yeah. This one says, in these moments, time stood still. And then it has their children's names, date of birth, a clock stuck on that time, and then their newborn pictures. This is the front room where Nicole Kessinger says the only place she went was the front room, which was complete lies, by the way. But this is where she said she sat and worked on Chris Watts' macros. And then the other sign on that wall says, every family has a story. Welcome to ours. Which wouldn't be creepy if it wasn't a house that people were unalived in, right? So there's the dining room. They have gotten rid of all of Shanann's bright colors. And then here's their family room where the TV used to be, I think, above that fireplace, if I'm not mistaken. Another view of the family room. And then the family room into the kitchen. Miss K says more like his micro. We all remember the orange detail that Shanann had in that kitchen. That is no longer there either. But the lights remain the same. The cabinets remain the same. The appliances remain the same. Even the linoleum floor is the same. Closer view of the kitchen. You know, the Watts made lots of memories in this kitchen. You did, Kristen? You almost bought in there? Island, I agree with you. I think that there are definitely spirits in this house. And I'm not saying that to be, goofy. I really do think that. I really do think that. And I don't know why they're selling so fast. They just bought it, but there's that back sliding glass door that will show you the yard as well. And we all remember this view. This is actually, creepy. This is like the exact view of, hang on, let me show you. That's kind of eerie, of the pregnancy video. Wait, right here.
We did it again. I like that shirt. Really?
Really?
That's awesome. So pink means...
That's just the test.
I know. It just says the pink is going to be girls.
I don't know. Just the test.
That's awesome.
Potato, you walked in just in time. And that's right where he walked through. She probably had all that set up on the island for when he walked in that day. Miss Robin says, I don't know how the house couldn't be affected. Meg P says the house is definitely haunted. And Franny says, I couldn't live there. And then look, they have two pooches. They've got a husky laying out in the sun on the deck, and then they have their other dog laying there. I wonder if those dogs could sense anything, you know, with all of the trauma that was in there. With Dieter and Dieter's barking and everything else. And then here's the upstairs loft area where Shanann would hang out with the girls a lot. And this is where a lot of the, let's see. Let me show you a little bit.
How you guys doing?
Like this upstairs area. Oh, here's their bedroom, guys. This is Cece's room. And then we'll also be going down in the basement. But here's this upstairs area here. See, that's exactly where they are right here at that door. And the Miller family had several children. I think 3 kids, if I'm not mistaken, that moved into all these rooms. Here's the master bedroom. And on the wall it says, "Always kiss me good night." Always kiss me good night. Let's go back here to the master bedroom and look at what that was like. 149 is the master. Right here. All right, let's go back here. More of the master. This is the Chris Watts house. This is Chris and Shanann's master bath. This is a second bedroom, I believe. And then here are the children's rooms. That would be Cece and Bella's rooms. And then here is the Jack and Jill bathroom. Remember in the body cam, the toilet had no water. The cop and the dog sniffers were in this bathroom. And then here's the laundry room. Same. Look at even the shelves. The shelves are the same. Here's the body cam of that room. Cece's little baby onesies. Look at even the rug. I think they have the same rug. Yo, now that is weird. Look, they have the same rug. Now that is Creep Town. That's pretty creepy.
When I looked at the sheets and the comforters, I don't see anything. It's kind of odd nothing's on the bed, though.
Yeah, real odd that nothing was on the bed, huh? Now this is the garage, and this is the entry door from the house, or from the garage into the house. And then here is the basement. It is weird, Potato. I don't know. Now let's look at some body cam from the downstairs basement. Well, that's at Nate's house. Okay, that's Chris's garage right here.
Okay. Okay.
I'm looking for the basement. Hold on. I should know these body cams by the back of my hand by now. Here it is. Okay, so here is the Watts basement, and I personally believe that Shanann Watts was unalived in this basement.
Okay, that's why we asked. Okay. All right, where are we heading? Anything I need? Nope. We got about 12 things going on this time.
So I think Shanann came home and went downstairs exactly like this to confront Chris about the affair.
They have not.
And I think something happened when she turned that corner right there.
That's interesting.
The black refrigerator is still in their basement as well. You'll see in the pictures in just a minute. Lots of medications in there. But here's a good view of the basement. Oh, Jesus. So they got an alert right around the basement stairs, and then again over in the corner there. Nicolae, isn't that scary? And she shushes him. He's alerting her, and she shushes him. Okay, let's go back to the pictures. Now, this is the basement now. They have a table. It looks like they have gymnastics set up down there. There's some little kids' dolls and stuff, too. And then here's another view of the basement. Remember, Chris had a bed down there where he slept. Which I think that bed was... Yeah, this is the area where all the medications just were. This area right here. See the fridge? Let's go back a couple seconds. I'm pretty sure they kept that fridge right in that same spot. Yep. All the shelves are gone.
That's interesting.
And the fridge is there. So that's the same area. When you go down the stairs and turn to the right, this is that area. So now we have the deck in the backyard. When the Watts murders happened, none of these homes were really lived in. They were just building this. They were just building this behind their house. So when Chris was actually interviewed, he made mention that there's no cameras back here and that someone could have maybe pulled up in the back and got her out that way. But there'd be no way to know because there were no cameras. But now you can see there's a sidewalk, and it really makes their yard look a lot smaller than when I was there because these condos were not that close. But now when this is Nate's house, when Nate's mom goes out on her deck right here, she has nothing to look at other than a condo. How nice. What a beautiful view. So now we have the little deck. It looks like they cleaned all the tumbleweeds out. It was all tumbleweeds underneath there. But they did keep the girls' swing set. And that's just the view. And that's it. That's 2825 Saratoga Trail, guys. Sad, isn't it? And super sad to think that if they would have if that would have never happened, their home would be worth double. You know, because part of their issues was money. Part of their issues was money, y'all. And they really made, a good investment with this house. At the time, maybe it didn't seem like it because their payments were so high, but damn, if they had just stuck it out. It's so freaking sad. It's so sad to keep going backwards in this case, and it just keeps coming up. But thanks for Potato for showing me that. Interesting that they're selling. We'll have to keep our eye on it and see if it sells quickly or if it sits on the market. Thanks for letting me show you guys that. Appreciate you.
Last name, no middle name.
Okay. No. And what's your last name?
M-I-U.
How do you spell, or how do you pronounce that?
Miu.
Okay. And what's your birthday? Do you like to be called Nicolae or Nick or
Nick.
what? Nick. Okay.
Yeah. December 11th, 1969.
Okay, so that makes you
52.
52. Thank you. What's your address, Nick?
5945 Hidden Oaks Circle, southeast.
Holy cats, that's a multiple.
It's a long one.
Hidden Oaks Circle. I don't even know if I have enough space in this link.
You do. Southeast.
Southeast? Oh, southeast. Thank you for correcting me.
No problem.
And that's
Prior Lake.
Prior Lake, okay. What's the zip code in Prior Lake?
55372.
Okay, and how about a phone number for you, Nick?
612-735-6317.
6317, and I understand you're married to Sandy,
Yes.
right? Okay.
Yeah. Is she okay?
She is, yeah. I did talk to her. I talked to her for quite a while. I brought her to get dry clothes.
Where is she?
She is with Ernesto and Amy.
Okay, good.
They're taking good care of her. And then
Titi, my puppy.
She's headed home to take care of the dog. And she's also with Ariel and who's his girlfriend?
Oh God, I don't even know.
Is it Tatiana?
No, Tatiana. Tatiana is another girl.
Okay.
But she's not.
Hold on,
with
they gave
Ariel.
me.
Yes.
Oh, Sandy didn't know Ariel's girlfriend's name.
Neither do I.
Okay. But Ernesto and Amy came to where I was with Sandy, and they went and got the car. But I had brought Sandy to the car to get changed.
She was driving, right?
No, she was with me. I brought her from the river to the car so she could get clothes, and we brought the cooler back and put that in the car. So she's got all the stuff.
All right.
Are you working anywhere now?
Mm-hmm.
Okay, where do you work?
I work at Ritchie Engineering as a mechanical engineer.
And what kind of engineering? What was that?
Mechanical engineer.
Yeah, what's the name of your employer?
Oh, Ritchie.
R-I?
T-C-H-I-E. Engineering. In Blooming. 55427, I think it is.
Okay. What was the last grade that you completed?
I have a bachelor's, and I have actually 2 degrees, one
Okay.
in engineering, one in mathematics.
Wow.
And I'm a class away from a master's in both. I'm not a dummy, and I've never had a run with the law, except when I got we'll go into
Okay.
that.
So where did you get your degrees from, your undergraduate
South
degrees?
Dakota State University.
Okay. Is that the Bison?
No, the Jackrabbit.
Oh, okay.
In Brookings.
And how about your master's degree? Where are you working on that?
I'm not working on it yet.
Okay.
Yeah, I did pass the EIT so that I could work
Gotcha.
for the state as a licensed engineer, but I haven't had a chance to do that. For many years, I worked as a contracting engineer. And then for the past 16 years, I've been working with Ritchie Engineering, where I met Sandy.
Okay. What does Ritchie Engineering do? Like, what do they manufacture?
What we do HVAC service equipment.
Okay.
Basically, we're the top tier of HVAC. We're like the top brand, and top brand for that is Yellow Jacket.
Okay. And is that for the parts?
The brand of yeah. Everything we make there, we make it under the Yellow Jacket brand.
Got it.
But
Okay.
the company name is Ritchie Engineering.
Okay.
So what I do everything from hoses, recovery machines, all the electronics. I talk to customers, I get business, I do the documentation, the design. It's a small company,
Okay.
so I like to do everything. Testing, evaluation, you name it. You know,
Wow.
16 years over there, and that's not even scratching the surface.
Really?
Well, I have bigger dreams now,
Yeah.
shattered, but anyway, I don't want to talk about them right now.
Okay.
I don't know exactly what happened, I just don't, I can't talk about it. I need to go one step at a time.
Yep. And if you have any questions along the way, Nick, just stop and ask me, okay? Or if you need to take a break, just,
How bad is it?
well, can we get through this form and ask each other
Yes,
questions?
yes.
I want to maintain the integrity of
Yeah.
this
All right.
investigation and your rights, and, you know, so I want to get through this form, and then we can ask questions, okay? So I'm going to turn this around. I'll give you this pen. What I'll have you do is I'm going to read each. You seem to speak excellent English.
Yeah.
You can read.
Yeah,
I would imagine.
Miranda rights,
Yeah.
which have not been read to me when I was put in the car. Is that
And,
right?
and that's okay, as long as they weren't asking you any questions, they don't need to.
Oh.
But I'd like to ask these questions, so that's why we're going to go through this right now,
All right.
okay? So I'll let you have that pen, and so I'm going to read these to you, okay?
Mm-hmm.
You have the right to remain silent.
Or just the...
You can check mark it, or some people put their initials. You know, we'll have you sign it at the bottom, so that's however you want to do that. Anything you say can be used against you in court or other proceedings.
Mm-hmm.
You have the right to consult an attorney before making any statement or answering any question, and you may have him or her present with you during questioning.
Okay.
And also,
What-
stop me, I talk kind of fast.
I was going to
Okay.
ask you about this one.
Okay.
So,
Yep.
when do I see one? When do I get one assigned to me?
You would get one assigned to you, the soonest would be on Monday.
Oh,
So that would be the soonest. And
working hours,
working
days.
hours, yeah, pretty much, is how that works.
Okay.
So if you cannot afford to pay for an attorney, you may be eligible to be represented by an attorney from the Office of the State Public Defender. If you desire an attorney from that office, you should contact their local office.
And that information would be provided to me, or?
Yes, so what happens is, the jail provides that information every day to the public defender's office, like here's who's on the list.
Okay.
So some people come into jail and they either have a lawyer already because of other things, or they know a lawyer, or they're gonna find their own. So these guys will let you use the phone if that's
I'll ask
kind of where you're at.
Sandy to look for me, if
Okay.
that's okay.
Oh, gosh, yeah, absolutely.
Because I'm not gonna see you and talk to
Yeah,
anybody.
nope, that's fine. If you decide to answer questions now, with or without an attorney, you still have the right to stop the questioning at any time or stop the questioning for the purpose of consulting an attorney.
Yeah, I'd like to do that at some point.
Okay. You can just check mark that, we went over that. However, you may waive the right to remain silent, and you may answer questions now without an attorney. You can just check mark that I read that to you. You're not agreeing to anything right now. This is just that I stated these things to you. So this says the above rights have been read to me. I have initialed each paragraph, or in your case, check mark, to show that I understand each of my rights. I have received a copy of this form. So
After I sign it.
you sign it, and then I'm going to sign it, Nick, and then I'm going to give you a copy of it. All right, I'll sign it here. And I've got 8:01. All right, just like that. Okay.
Military time.
Sorry, do you want me to write it regular? Okay.
No.
I get so caught up in used to that.
Yeah.
My friends don't like it because in my vehicle, my own vehicle that I drive, it's military time, and so they're always asking me what
Everything
time.
I have is military because I came from Europe. And
Oh, sure.
everything
Yeah,
is they call it military, but it's not military. It's
Right, it's
the proper time.
exactly. Well, good. At least then you know what it means then when I put the time on there like that. So I would like to ask you questions about your day today. What happened? Like how you guys got to be in the Apple River today, and then like what your day was like. It's up to you if you're willing to answer questions. If you decide that, yep, I'll answer questions right now, and in 10 minutes you don't want to answer anymore, you just need to tell me that, okay? And if you don't want to answer questions right now, then that's fine too, and I will leave. It's up to you.
All I can say, it was self-defense. Self-defense. There were lots of people that came on to me. Self-defense, and they produced 2 weapons. One I took from them.
Okay.
That's the only thing I can tell. And they hit me, and they were on top of me, and I don't remember anything after that. I just remember I ran away. I ran away to my group. There were actually people coming over from my group to see what was going on. I said, nothing, just get back on. And they kept asking, and I said, nothing. I didn't explain to them anything because I was so fearful. I didn't know what these people were doing to us. I've never been in a situation like this, where people produce weapons and they were saying, they were calling, I don't remember, but they said, don't run from us, don't do this, you're a child molester, you're this. And I said, are you people drunk? Or you're a child molester. I said, the only thing I remember in my mind is, if I'm a child molester, should you be drinking? Should you be drinking alcohol and doing what you're doing to people that you don't even know, attacking them? And I said, if I'm a child molester, you should be having alcohol, And they took my, I was snorkeling, so they took my snorkel away, they threw it in the water. They grabbed my pants. One wanted to pull my pants down, and I grabbed onto him. And I don't know who that kid was, but he had a knife on him. And then there was another knife, a longer knife, looked like a kitchen knife, kitchen or something, I don't know. And I don't know what happened to either one of them. I just know that when the kid attacked me, I took that from him.
The kitchen knife or the other
No,
knife?
the smaller knife.
Okay, what did that knife look like? Do you remember?
I don't even remember.
But it was smaller?
Smaller, yes.
Okay.
So, that's all.
How did you get to be by them? Or who are these people?
So, Ariel lost his phone.
Okay.
The phone was in the floor.
One of those bags? That
Yeah.
Okay.
And everyone had one, but his phone was in the floater, so he says, well, let's go look for it. So I put my snorkel on, and I looked, and these guys found something, and they were talking about it, and I said, okay.
This group of people?
This group of people,
gotcha.
yeah. I went over and I said, did you guys find the phone? And if you did, can I see it? Can I identify it? And they started calling me names. They got off of their tubes. They came at me. Like I said, all I need. And they were calling me all kinds of names, insulting me for being in the water with a snorkel. And I said, all I want, guys, did you find the phone? And I saw they had found something. Okay. All right. And I don't know if there was a phone or something else they found, but they wouldn't talk to me about what they found. And we were looking desperately to find this phone. And I know somebody found it, but I thought it was that group.
Okay.
You know, and then they went over, they came to me and they grabbed my snorkel and they threw it in the water. Well, the water was so fast, it went under. So I went out after it, and they started, another group of mostly girls came over from the other side, yelling at me or calling me child molester and something with something like that. And I went back. I actually after this incident, I don't even know what happened. I just know that they attacked me, and I was in self-defense. I went into self-defense mode, and then I went over to my group of people. That was it. And they asked me what happened, and I wouldn't tell them. I said, I can't tell you. Let me calm down.
Okay.
I was shocked. So nobody on that knew exactly what happened. The only thing they said was, look, somebody got in an argument over there. Like, yep, let's just leave that alone. Don't go there.
Are you able to draw for me, like, where you were looking for the phone, like, and where was Ernesto and Sandy, and where was this group? Maybe it would help me kind of understand. Yep.
These guys were here. I don't know how many. There were quite a few.
Okay.
We were upriver about 100 feet. Our group was here. And
So you guys were in the water?
Yes. Yeah.
Okay.
So we were in the water. And then there was another group of people over here that came to attack me. So there was this group of people here, this group of people that attacked me. They attacked me here.
So your group was floating down the river like this?
Actually, we're stopped. But yes, this is the
That's the direction you were going. Okay. So your group is stopped.
Yeah.
And who's looking for the phone besides you? Like, how do you know the phone's missing?
Oh yeah, we talked about it. I yelled.
Oh, okay.
I lost my phone. And I said, well, you didn't lose it. It's floating down the river.
Because it's in that bag.
Yeah. So let's go find it. You know. And he was over here pouting that he lost his phone, and I said, that's okay, I have my snorkeling gear. And then I heard this guy said that he found something. And when I was snorkeling down, I passed him. I kept looking, and then I came up, I kept looking, and then they started yelling and screaming, and I said, did you guys find something? And I thought they did. And I know they did, because they were hiding something from me. And then I went over there and they grabbed my snorkel, they threw it down. They got off their tubes, they came after me, they pushed me, one of them hit me, and then there was a girl that came from here and hit me in the back of my head. And I was about right there.
You said right here?
When she hit me, yeah.
And that's when the female hit you?
Yeah. And she was coming from another group over here. I don't know how many people were in there. But
were these guys stopped?
Yes, in very shallow water.
Okay, so it's really shallow over here.
Shallow there.
Okay.
Pretty much the two sides are shallow. Yeah.
Was it how deep do you think it was when you were like snorkeling around looking for the phone?
4 or 5 feet.
Okay.
Not very deep. And the water was very murky, so I could not see anything.
Really?
Through my goggles. But those goggles are lost. They took them, they grabbed them off my face and threw them in the water.
We found the goggles.
Oh, good. Thank you.
And the snorkel.
Yes.
Yep.
Yep.
Are they connected?
Yes.
Oh, okay.
Yes.
And they're just like regular snorkel goggles, right?
Yeah, I had them over when I went to the Caribbean.
Okay. What do they look like, just to make sure we have the right one? White?
Well, transparent plastic with the white snorkel.
Okay, all right.
Is that it?
I think we have them. Was there any, did it seem like these groups were together?
After they came after me, I don't know. Yes.
Okay.
Yes, I think so. I mean, I feared for my life. Tell you the truth, when they started hitting me and pointed a knife at me, and then another kid pointed a knife, I thought that was it for me. Luckily, I took it from one of the young kids, and I think that's when I swung back.
What did you do with it?
I don't even know.
Okay.
I don't know. Absolutely, I don't know. I don't know if he got it back. I have absolutely no idea.
Did you hit him? Like, did the knife make contact with him?
That I don't remember.
Okay.
You were so close.
Sure.
And one had it in his hand, so I took his hand and I bent it and I poked him with his own hand. And then I took it from his hand and then I went and swung like this. So I don't know who I hit. I just know that I took the knife from one of the kids.
Okay.
The other one, I don't know what happened to. I didn't get hit. Because as soon as this happened, I started running across. So I went across to my group, and then my group was wondering what just happened. Was it? And I didn't want to tell them anything.
Just because you didn't want to.
I didn't want to get anybody aroused. I didn't want my group to go say, well, we're gonna go talk to those kids. No, they were too drunk. I believe they were too drunk and too set on going after people, I think.
What were these guys doing? Did they know anything was going on?
No.
So they didn't know you were getting punched or?
Well, they saw the scuffle because at one point Ernesto was coming towards me like, hey man, did you find anything? And I said, no, I didn't. I don't know. These guys must have it or something. I don't know. And he says, okay, well, he will just get another phone on Monday. You were concerned about getting the phone. And like, okay, so what are you doing? I said, I don't know, I'm just gonna go late to sit in my thing. And then Sandy said, okay, are you okay? And said, I don't want to talk about it. You know, and then they asked me, hey, what do you want to do? You want to stay here? You want to go down? And I said, I want to go down. And then some girls from my group heard that something was happening over here, and they said, well, we're calling the police, and I think they called the police.
Okay.
One or two, I don't know.
Did you see any of
And good afternoon from our live streaming center, Fox 9's Gavel to Gavel coverage of the Apple River stabbing trial. You can see Judge Michael Waterman is back on the stand, back on his bench. It is 4:26 p.m. Central
Here we
Time.
go.
We are told the jury has another question.
Jury
After this
question.
We'll all fill in the blanks afterwards. Let's go right out to Hudson, Wisconsin.
In session, the attorneys are present. Mr. Miu is present. 12 jurors are present. Members of the jury, the bailiff has notified me that you would like to adjourn, go home, and then come back tomorrow morning. You're nodding your heads in agreement. That's your preference. That is your prerogative, so we will follow your wishes.
It's my prerogative.
The warnings tonight are the same as before. No independent research, no investigation about the case. Do not view any media reports, social media posts, internet commentary, or video about this case. Do not talk with anyone about the case either. It would be highly improper for anybody to attempt to influence your judgment at this stage, or any stage for that matter, of these proceedings. The bailiff will take you out. Let's come back tomorrow morning at 8 o'clock. Okay, 8 o'clock, same routine as before. Please take the jury out.
All right. Oh, we're live. That's what happens in these court settings. Back in the Fox 9 live streaming center.
Gavel to gavel coverage here at J is for Justice. We will be back here at 8 a.m. their time, which is 9 a.m. Eastern Standard Time tomorrow. But before that, we have Brian Koberger at 7 p.m. tonight on the surveys. So I think they're going to bring their expert up, talk about these survey questions, and decide if the survey will go on. They already did Latah County. Can they finish up? We'll find out at 7 p.m. tonight. Thank you for watching today. We're going to run our credits, and I'll see you guys in about an hour and 10 minutes.
objection. All right, since there's no objection, we will plan for that. As soon as the jury arrives, we'll assemble in the courtroom. I'd like to have the video connected and ready to go, and then we'll follow the same procedure
They want to
as we
see
did
the video
earlier today.
again?
No comments, no commentary, no opportunities to persuade or influence the jury. They're simply coming in to view the video, and then they will return to the deliberation room.
They want to see the video again in the morning.
Start then at 1:40?
I don't know what the time would be. They're just asking for 10 seconds before the confrontation with Maddie Cohen. So I'll let the attorneys identify what point in the video that is, and then we'll display that to the jury. Beg your pardon?
Maybe you don't want us to talk about it right now, so I was
Yeah.
going to talk, but.
Yeah, you guys can figure that out, where in the sequence it should start from. Anything else from the defense?
No, Judge.
All right. Have a good night, everyone.
Can I approach?
Yes. We'll see you tomorrow.
All right, guys. I'll see you guys in the morning. We'll be back at 9 a.m. Eastern Standard Time. I'll see you guys in about an hour and 10 minutes for Brian Koberger. Right here on J is for Justice.
Where do you think you're going? Nobody's leaving. Nobody's walking out on this fun, old-fashioned family Christmas. No, no, we're all in this together.
Be sure to check out my other videos and playlists for more true crime content. And if that's not enough, you can join our Patreon. Don't have a tinfoil hat? It's okay. We'll make you one. It's that easy. See you guys in the next video.
See you later. Bye.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. 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 You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time for that.